Why? No. Do it. This is an opportunity for the juniors to do it. This is a good opportunity for the juniors. So what are matter? Quantum is not very important.
My lord, actually,
Let us see.
what happened? Stay application I have moved. Stay has been granted on the condition, but the problem.
All were directed to be deposited.
But for the main application, the client wants the
Nothing.
counsel to come.
Come. Don't worry. Come.
Item number 22 and 26.
Yes.
I have returned the file to the government.
Yes.
I have returned the file.
Which one?
22, item 22 and 26.
Let us call first.
My lord, my lord. My lord, in this matter, Mr. Binnu and myself are your lordship's special officers. This was a suo motu public interest litigation, which was initiated by the honorable judges after they had done a driving trip from here to Diglipur. The condition of
the road is very bad.
it was non-existent. Thereafter, we have been monitoring the road. We have been going up and down with inspections, filing reports. From November last year up to June this year, out of 332 kilometers, a lot of work had been completed. There was about 68 kilometers and odd which required to be done. Unfortunately, at that point of time, there were various other circumstances this court was looking into, and this court had imposed a fine of rupees 100 crores for various issues on the National Highways Development Corporation. Challenging that order, the National Highways has gone to Supreme Court. Supreme Court has stayed only that portion of the order about the deposit of 100 crores. Rest of the matter stays alive. Now, the problem is that Mr. Binnu and I are both aware, because we are still getting the reports of the situation. The situation has gone from bad to worse to almost critical now.
The roads are not regularly repaired.
First of all, with the monsoon starting, no work can be done. The road now, whatever was there, has gone to the extent that vehicles are literally in critical danger. A. B, we are informed that that entire area, because of problems with the drainage, areas which were never flooded are now up to neck deep water. Houses are inundated. People are in really bad situation. If your lordship permits, we would show your lordships of videos that have been sent to us. In addition, there are places which now are contiguous to the sea and the backwaters. The NH is now covered with 1 foot of water in some places. There is a fear of crocodiles. There is a fear of all sorts of things. Now, some immediate remedies perhaps are necessary for the simple reason that the Supreme Court had fixed this matter on the 25th of August. Thereafter, matter was not listed. Now, from the Supreme Court case status, we are able to ascertain matter would be taken up sometime at the end of October. In the meantime, there is a real problem over here. People who live anywhere north of Jirkatang, all the way to Diglipur, people who live near the highway or have to use the highway even to go to school, market, things like that. It's impossible. And in the last 2-3 days rains, I am informed there are persons present in the court, connected with the court.
And what about this, the drainage and all, everything, the sewerage?
The problem was that the drainage work was not being emphasized. The emphasis of this court was to make the surface.
Who is responsible for doing all these drainage?
The entire road is under NHIDCL. Now, what they have done is they have broken the entire length of the road into packages, and one package was tendered. So you have contractors for each of the packages. Now, the road surface, the court has been monitoring, and we have seen a lot of work had been done prior to the rain starting. But the drainage work and the culverts have to be made, because otherwise the road has raised the height.
Yeah, absolutely.
Now, at that point of time, we informed the court about this in our records, and the court had asked for this work to be done. NHIDCL said that drainage work is not required along the entire length of the highway. Where it is possible, we will do it, because in the monsoon, there's no problem with doing that work. That can be, because that requires casting of concrete and things like that, which is not a problem in the rain. But today we are seeing a situation, if your lordships desire to see those videos and photographs, I can show it right now. But the situation is really bad. There are some places, some places the water has reached the transformers on the electric pole. So there's no electricity last 2-3 days. Bathrooms are inundated, toilets are overflooded. The situation is unbelievable.
But I think highway is being represented by Mr. Hon'ble. Mr. Hon'ble is appearing to the action.
I am appearing for initiative here, but that is what our experts, people call the point of time was not required throughout the states. That we indicated before the special officers also. And only 57, that point of time only 57 kilometers were remaining for the construction. There were certain problems with the contractor whom we already removed. Fresh tender, we are awaiting the approval of the ministry. Soon we'll get that. For the time being, what the entire responsibility, what has been attributed to us, means we are not responsible for the entire thing. We are responsible for the road and certification of the drainage. Now, for the civic amenities, the administration and we both of us can take a joint call on this issue. Because we are not facing any adversary litigation, we are also concerned about the people over there.
But now look at the situation, because today what we have projected before as the scenario.
Yes, madam.
We have that it has gone up to the height of a transformer, and the transformer may at any point of time may submerge into the water. And we look at the person that in a modern society, where we are more concerned not only on the constitutional right of the individuals or citizenry, we are more concerned with the human rights. And the electricity is one of the very essential mode of life.
Absolutely.
Nowadays, in present scenario, nobody can live without electricity. Even my lord, I was also take a call because he says that if the sewerage system is properly, the repaired, then in that event, at least the accumulation of water you can avoid. I can understand this so far as the construction of the roads are concerned. The special officers are also very sensitive about it. They say because of the rainy seasons, it may not be possible at that point of time. At least the people must live. You can't just be so apathetic. No, actually take immediate steps. And what the civic communities, the authorities are doing, are they not taking any steps? Those residents can't visualize the situation. The only mode of communication is the now, it appears to me. And
the life jacket, they're riding motorcycles instead of helmets. There's always a chance, and even what I was informed, that is most alarming, that the crocodiles,
obviously, because you have that,
yes, even without electricity, a person can survive, but this
it's very difficult.
That there is a life danger,
and that concern with the comfort.
So, both
life to life is a different concept.
Both of us, let the civic services providers, the administration, as well as
the difficulty is the moment they go there and then do something, then the National Highway authorities will say that you can't encroach upon my. That's what I find from on this side and that side of the road. Well, I had both the privileges.
Yes.
Are there. The only thing is there is no bridge, there is no connectivity, there is no synergy.
Yes.
Not even a convergence between the two different authorities.
From the very first date, all the parties have been trying to resolve this issue.
How? But something has to be done.
Yes.
Some steps. You have appointed a contractor, you may have a civil dispute with the contractors. But for that purpose, the people or the citizens cannot suffer. And this area, because of this topography, is a very,
immediately
what says.
What can be done, I'm not a technical person, but still what I feel, immediately if we can address the issue of draining out the waters.
Absolutely, that is first and foremost responsibility that we'll have to take care. And we'll have to drain out
the water, and for that, both the administration and NHIDCL.
But the only thing is sitting on across the table.
No, absolutely not. They have to visit the field and take a stock of the situation as it is.
But you can't visit also. You'll have to visit through boats.
My lord, kindly envisage someone in Diglipur who needs medical treatment. Helicopter cannot fly in this weather. Boats are delayed or not functional. You can't come, you're just cut off. It has reached a point where the political establishment has threatened hunger strikes from the first. All along the road, people of the villages are saying, we are going to go on strike, we're going to shut down the road. It is going to become a law and order problem next.
Just imagine.
Yes.
And the national highway is not, according to him, is not visible at all.
No.
My officers are there, my lord, that part is there, but the thing is that, my lord, so far as the black topping and other part is concerned, as has fallen from your lordships also, at this point, it's like impossible because it will be again washed away. Now,
No, I understand. At least somebody can just use those roads. At least those roads are visible. It may slow down the pace. I can understand because of the incessant rain which has come. But roads are not visible. The waters are accumulated. They have engulfed the whole of the national highway and a long stretch. Then, and the draining, what your civic authorities are doing? Are they not in tandem with this national highway
My
authority?
lord, in our report, we have categorically stated, my lord, drain work is required. At that junction, the court also asked them, they said, no, it is not that in all the stretch the drain work is required, but that requires, because in our report, we have specifically stated that it is required. Now, kindly see what is the situation today. Because of their non-cooperation, this situation arrived.
No, my lord, that portion, my lord, what our expert team has taken a note that in not the entire stretch, where there is enough space.
Sir, when the special officer was there to monitor the entire thing, and when the special officer definitely with the help of some kind of experts from EPW, if they have said that you require to clean up, you require the free passage of the foul water or the water, rainwater, whatever, pass through the drain.
Yes.
Then you can't say this is stretch, that stretch, because the accumulation definitely at one stage or one stretch, it is not going out. There is a complete locking of the water, and that really augments the accumulation.
Yes,
And there is a complete deluge system. A deluge, I think, is a completely there is a deluge.
If my lord sees those videos, the man who is standing and talking to the camera, he's up to his neck in water, it's still raining, it all when he cannot stand. My lord, the house behind him has water up to the windows.
That's true. That you can't do it. Where is your civic authorities?
I'm representing them.
Absolutely, this is what I find from the earlier order, that you are representing the administration. That's why I'm asking. What they are doing? They are appears to be absolutely they have closed their eyes. They are absolutely blind to the situations. And that is what my experience is, shocking the responsibility from one shoulder to another.
No, my lord, nobody is, my lord, because this is we at the very outset we mentioned, my lord, this is not an adversary litigation.
No, it is never
concern. Now, my lord, the fact remains is that in certain portion where the videos has been, my lord, been circulated, there, my lord, I was, my lord, specifically informed that that was for a specific period when there was a heavy downpour. Subsequently, my lord, the water, my lord, definitely. Yes, in certain portion.
Can we request the special officer?
My lord, as of today, I have taken instruction, your lordship will not take me amiss, from one of your lordship's own court officers who lives there. He has sent me the pictures today morning where the water is 1 foot on the height.
Just imagine.
Yes, my lord, there was.
Whom to believe? Whom to believe?
We are not in a position to go there now, we cannot ascertain.
And the administration.
Cooperation of the administration, we should take all steps and we can file a report.
No, immediately, because we wanted that by 2-3 days you'll have to do it. We are fixing this matter and we wanted everything to be done in this matter. And some steps, some kind of a report, and if necessary, the special officers, you will also go and.
My lord, it will not be possible for anyone to go there.
No. Just try to reach. If you find that you cannot reach this.
No, what can be done perhaps is when we were going, we were interacting with the junior engineers and executive engineer of APWD all along the way. There are people posted at every place. And each of them can immediately give a report back to us.
Yes.
Because we have been working through the APWD officers.
Okay. So there is no difficulty.
Well, may I take a scout instruction, my lord?
Take an instruction. Do one thing. We are keeping this matter at 2. You take the full instructions. Come back with the viable solutions. And your zeal, may I use the word, zeal to erase or eradicate those kind
My
of.
lord, I mentioned the matter, that's why, because I thought, my lord, it is proper to bring it before your
No,
lordship.
that's true. That's a good gesture on your part. But still take a fullest of
My lord.
take a stock of the entire scenario today. Come at 2 p.m. and tell us.
Matter.
Why do we mention
For
madam?
instance, no, I'm for the respondent. This can be taken up. Section 5 is pending for consideration. Appeal is there. And it's an appeal against the award of the reference court under the Land Acquisition Act.
My lord, in this matter, my lord, Rakesh Kumar sir is appearing for the petitioner, my lord. I pray for short passover may be given. He will do the matter today.
It's a land acquisition appeal.
Yes, ma'am. They have to pay the amount, lordship, they have to deposit.
Did you, they have they secured any stay order?
Nothing, nothing.
Then you can proceed with the execution.
Yes, no, let just one line be added. Rather,
What-
because they are
what?
not before the executing court, already execution case has been launched.
No.
They are informing the executing court about the pendency of these appeals.
So you
Just one
convince
line be
them,
added, lordship,
convince
pendency
them.
of these appeal would not.
convince them, you know the law.
Not true, not true. But
What
sometimes it happens
convince
so,
them?
not
It's
sometimes
what
it happens
happens.
so, because the
Sometimes-
trial court is guided by lordship, the fact that its appeal is pending before the high
How
court.
can they guide? What the amendment has been brought?
Now,
What the amendment
those
has been
things have
brought?
been placed, but what I
Sorry?
pray, just one line pendency
You
of the
just show
appeal.
them the provision of law that you can't do it. You can't do that. Show them a provision of law.
This has been shown, lordship, that
What provision you have shown?
Order 41, rule 5, no, there is no
So-
stay. There is no
So
stay of-
show
It
him.
has been done so, but the court is saying that since they have been informing the executing court, appeal is pending time and again. That's
No,
the ground where not should
there
be.
is no appeal in that sense.
Not, it's not.
Section 5 has not been
Absolutely,
allowed.
no, just one line be added. nothing.
So what, why will you
They
leave
have
the
taken
order?
up the application for stay.
Bring him.
Lord.
Section 5 will be here. Call him.
Your Honor, my lord.
Pass over.
In this matter, my lords, there were two aspects which my lords had indicated yesterday. One, my lords, is regarding the SOP. My lords had said that to find out whether the SOP,
Yesterday I did not open the brief.
my lord,
Now I am fully equipped with the facts.
my lord. My lord, then I'll await your lordship's indications and only their address.
Yes.
So, my lords, as far as the SOP is concerned, my lords, I have ascertained, my lords, there is no, it doesn't have the force of law. There is no statutory, there is no statute at all. And as far as this IRBN force is concerned also, they are to all intents and it is headed by the Director General of Police. So it is not as if they are some independent chain of command like the CRPF, etc.
But what your reply before the
No.
trial, the tribunal was?
Yes.
Suppose it.
No,
May I
Yes,
refer those pages,
lord.
what you have said?
it is headed by the DGP, of course.
Yes,
Otherwise,
what you have said in your reply. Have you seen?
my lord.
154. Last 3 lines. From the bottom. However.
That is not reading also.
Yes, my lords. No, that is right, my lords. We are not, all that I'm saying is the,
So what does it mean?
so,
So if it is an independent organization,
yes, my lords.
then what
So-
it means?
Yes, my lord. So now, as far as the they are guided by CCS rules, and the disciplinary authority will remain the commandant. The SP does not become the disciplinary authority.
So you have said that somewhere they were adopting some policies in some states. They were adopting the CCA rules. You have pleaded everywhere. At page 160 also in paragraph 7.
My lord.
Subparagraph 7. You have
My
said
lord.
so.
My lord, yes, my lord, said that. So, as far as the adoption of the transfer policy, I've
Now the
got,
question is again, if it is absolutely a separate organization,
my lord,
absolutely separate, independent of the police, independent of the security forces,
my lord,
it is something which is very unique because I find 1007 posts were sanctioned for this island.
my lord,
913 have been deployed or been said, you have appointed. So in that event, the total, the nature of work is absolutely different.
my lord,
They are just a standby or emergency units which are set up, that in case any emergency is required, they will be immediately
my lord.
contacted and they will support to the police administration also.
My lords, in fact, the transfer has been done in aid of this, what my lord is saying. I've got the file notice.
Difficulty is, I tell you very frankly, posting them within the police station is a big hilarious task.
The fact is, they were always posted whenever they were sent on for those particular jobs.
Can you show, you have not disclosed anywhere in your opposition, in your, I mean the reply in the tribunal, here is an opposition. So you have never said anything in your reply that they were all along posted there. And you talked about certain, the consent which you obtained, but these persons never gave consent. Now, if others have given consent, that will take away their statutory or the constitutional right.
No,
I don't think so.
No, certainly not. But
so in that event, you'll have to justify.
Other aspect, my lords are also put it to me. My lords, the file notings, my lords, that contains the rationale because there is no other statutory force. I've got the file.
But I believe that there should be some kind of a policy you should adopt. You can't do it in this way.
My lords, permit me to just show this. This contains the policy, my lords. At least in the executive instruction and policy is there, my lords. May just have page 5 of this. This is page 5. This is the proposal comes. The first 3 pages are proposal from the IRBN itself. Now, my lords, may just have page 5. This is 33, Placitum 33. This is regarding deployment policy of fighting staff of IRBN. At present, the headquarters of entire IRBN personnel is Port Mount. Yes. The staff of IRBN is detailed and detained / deployed.
Detailed and deployed, I do not know.
Deployed on temporary duty to NNM Andaman, Nicobar and Swarajdeep to assist local police in police station. This resulted in expenditure on their transport and TADA. Moreover, the deployment of IRBN personnel is at police station level. Half a sector or even half staff is not in accordance with deployment pattern of CRPF, Central Paramilitary Force.
Correct.
The present proposal is comprising of 1 deployment of IRBN at the level of platoon in the district
or
COI in the district. That means that the headquarters of IRBN will be designated that particular duty station in place of Port Mount. This will help in saving expenditure. Further deployment is proposed as under COI NNM Andaman. This will further bifurcate at platoon level stationed at Diglipur, Mayabandar and Rangat. This will help in avoiding accommodation problem at one place and further retransportation. COI Nicobar, this will be further bifurcated at platoon level stationed at Car Nicobar, Campbell Bay and Nankari. Platoon Swarajdeep, the transfer rotation policy of ANN police will be applicable on IRBN staff. Staff will be deployed at these stations on a normal regular transfer. They will perform the guard duty at court, DC bungalow and other important installation. The civil police deployed for guard duty will perform regular local police duty. By adoption of aforesaid proposal, it is estimated to saving of rupees 1.82 crores on account of TADA. The present deployment and proposed deployment is shown at flag C At present, 129 of such IRBN are deployed at NNM Andaman and Nicobar district. In the proposed deployment, 168 of IRBN will be deployed. In view of the proposed deployment plan as mentioned, an adoption of transfer policy of ANN police on IRBN. And this is signed by the Director General of Police, who's the overall head of all the of the local police and also the IRBN. So this is the rationale behind.
But what was I could not find from any documents which you have annexed. You have annexed one document, but it does not show that they have any linkage with the police administration. I do not find. There is only one document which is forthcoming from your end. But it does not throw any light at page 87 if you come. That's the only document which says that because it talks about the 13 crore cost at that point of time, but look at it, the absolutely a different purpose.
Yeah, but this funding is from the UT administration.
No, that is true, but have you seen? Now I'm reading for you. I am directed to convey the sanction of a president for raising of one IRBN by UT administration of the Andaman and Nicobar Island. The standard cost of raising of this IRBN not exceeding an amount of 13 crores will be reimbursed by the central government. The condition of the reimbursement of initial raising cost and other guidelines for raising of one IRBN are indicated below. Under the scheme of IRB, the Government of India needs the standard cost of raising IRB by way of 100% grant in aid to UT administration subject to actuals. The battalion is required to be raised broadly on a pattern fixed by the Government of India. The standard pattern, authorization of transport and wireless equipments, arms and ammunition is enclosed in Annexure 1 and 2. As far as the UT administration is concerned, in addition to annual recurring expenditures for the IRBN, the UT administration has to incur capital expenditure for providing a basic infrastructure. That is what is, that you'll have to give them a building and all everything to establish to the battalion. The expenditure on the battalion after initial raising is borne by the UT administration. However, if the battalion is deployed ex-state, the expenditure is borne by the following state. When battalion is deployed in any of the exempted category states, the expenditure is borne by the different. Now you are exempted category state. When the battalion remains undeployed as reserve for the central government, the expenditure is borne by the central government. In all situations, the UT administration concerned meets the expenditure of the Indian Reserve Battalion. During 1999, this ministry has circulated a syllabus of basic training of the IRBN by Bureau of Police Research and Development. The training of the IRBN accordingly has to be based on a model training syllabus in order to make this IRBN operationally effective as and when deployed outside their parent duty. The recruitment of personnel for IRBN would be made by, I believe, the constitution of a selection board on a regular basis within the UT. Once the representative of the CMFF not below the level of commandment will be the member of the selection board. The member will be nominated by the Ministry of Home Affairs. UT administration should request in advance prior to intermediate recruitment process by this. The Government of India exercises the first call on is such and such. This means the Government of India have a full authority to ask the UT administration to make the battalion available for deployment elsewhere in the country as and when required. The UT administration will be bound by such guidelines and instructions and will be issued by the central government from time to time on this behalf. Since the battalion will be required to serve anywhere in the country, the UT administration would, at the time of recruitment and training, take care to ensure that he has a cosmopolitan character and is suitably oriented. If you look at the purpose of this, it does not talk about anything else.
My lord, may I have point number B for a moment, my lord, page 87.
Yes.
My lord, this says that if my lord sees how if the battalion is deployed ex-state, expenditure by borrowing state, when deployed in any of exempted state, expenditure central government, when remains undeployed as reserve, expenditure by, in all other situations, UT administration concern meets the expenditure. So unless they are deputed outside the state,
yes,
If they are deputed outside the state or on service of the central government in some other area, then they will bear the expenditure. But otherwise, it is the UT administration who has to bear the expenditure.
No, that is why, because it is for them. That's why you say the infrastructure means the human resources shall be placed.
My lord.
But so far as their infrastructures are concerned, that the building, headquarter, everything, that would be provided by the UT administration.
Yes,
and
ma'am.
they have to bear.
Yes, my lord.
They have to. This is what is, then the judiciary would also go under the UT administration. All these court buildings are being maintained and by the UT administration. Then it will go there.
But my lords, eventually the
How can it be done?
improved transfer.
Nature is
My
that
lord.
you are not connected with the UT administration
My lord.
except so far as the infrastructure
My lord.
or the expenditures are
My lord.
concerned.
My lord.
All control is with
Yes,
this
yes.
central government.
Now, but even
Be it direct or
My
a
lord.
pervasive.
my lord.
Control is of the central.
My lord, but the 4th August 21 is an order issued by the IRBN, not by the administration. So IRBN is saying we want to adopt the
And
transfer
this
policy.
is the Ministry of Home Affairs. It is not.
My lord, I
IRBN.
appreciate, my lord.
There is a selection board for recruitment. You can't do that. There is a selection board constituted by the Ministry of Home Affairs. Question is that you can definitely, it's a transferable one. You can transfer to any other place. No problem.
Yes, ma'am.
But the problem would be that whether posting them in the police station is the main
But
issue.
my lord-
They can function as a police personnel within the police station.
My lord, they were doing that even earlier as per that file noting which I.
So I do not know that is what is there.
In fact,
Nothing came from anybody.
my lord. It is now, in fact, it is being said that it will be per district platoon. Otherwise, earlier.
Has to be because it was a headquarter.
Yes, my
I
lord.
tell you, what it appears there from was
My lord.
that since they were stationed at the headquarter,
My lord.
as and when the exigency or emergency arises,
My lord.
the battalion has to travel to
My
that particular spot.
My lord.
For that, the huge amount of TANDA was spent.
Yes, ma'am.
So what they say is that if it is in a district-wise manner, if they are deployed, then in that event, we can avoid the TANDA, which is 1.83 crores
My lord.
per month or per year. I have not checked out.
My lord. It should be per year, my lords. No, but my lords, must just have one line, my lords,
Yes.
page 5 of the note.
Yes.
Earlier on, this refers to the earlier days. Moreover, the deployment of IRBN personnel is at police station level, half a sector or even half staff is not in accordance with deployment pattern of CAPF. So at present, in the earlier thing, they were deployed to the police station. Now it is being done on district basis. So as a transfer policy, you are saying that per district division, this is actually
Can
more
you show us
in
the earlier order of transfer? Can you show us the earlier order of posting prior to this? That it was a routine feature. Prior to this particular note, can you show us that this being deployed, this being done in this fashion? No difficulties. You have not made out any case of such nature. This is something you are coming up for the first time at the bar. You never meet those points in the reply.
Because we didn't face that challenge, my lords. Now we are before the High Court.
You never faced challenge earlier.
This challenge we did not face, which is,
That's
that's why we are only respondents.
easy passes to you. That means that you will not do it.
No, we are respondents, sir, my lord. So therefore, we were only responding to the case that.
Only thing is that you have said something in your internal document. You have said something. There must be some corroboration. There must be earlier orders of transfer. There must be something which you have done.
Transfer, yes, my lord. I appreciate, my lord. I
So,
can file that.
Or something that you have posted him, you will be attached to this police
I
station.
can produce all that, my lord.
Produce it.
We'll do-
Produce it. If it is there,
It cannot
Who is
be
there?
this way, my lord. All the records are available with my lords.
whatever. We can exercise the writ of certiorari.
To us.
Where is the difficulty?
No, they are assisting, they are traveling beyond the scope of the
No, it is
petition.
that-
What reply they have filed?
Nothing. I have seen that. The only thing is your contention is this. That you are a different organization, separate organization. You cannot be posted at the police station. You can't do it.
That I am able to demonstrate, my lord.
What you have done is this. Now they have come up, it says that no, it was all along. The
My
posting
lord,
was
can you
allowed.
visualize the situation if it would have been all along, what
Only
issue and all.
thing is the employers are the best judge
Definitely.
how to extract the best potential from the employer. If they have
But when
chosen
there is a
something,
statutory-
it must be, yes, it is, must be within the statutory framework. Produce it. Produce
My
it.
lord, kindly visualize.
And the nature of
Yes,
the duties which they discharge,
my lord will produce. all.
not in a regular investigating manner.
We'll do that.
It is not a regular investigating
My
manner,
lord, my lord, we'll.
but you can't do that.
Yes.
When tomorrow,
Yes.
bring it tomorrow, give it, come tomorrow. The respondent is directed to produce the relevant records pertaining to the posting and deployment of the IRBN personnel, Indian Reserve Battalion personnel, in a police station prior to the order of transfer / posting issued in the year 2021. Let this matter be taken up tomorrow. Yes.
Here, my lord might have gone through that. This is that sub-inspector, my lord, price of 5,000.
My lord, that fallen from the bench that we should examine the legal.
No,
Tell us,
my lord.
what is the scope of judicial review in relation to a disciplinary proceedings?
If it is patently illegal, my lord, definitely.
I do not know. The scope is very limited.
My lord,
To what extent the court
the
can.
decision
I
making.
have seen your synopsis. You are trying to raise every issues. At one point of time, you said that one Ravindra Singh was to come as witness. He was not permitted to adduce evidence. Later on, it appears that yes, he deposed, but nothing could be taken out. You have said that you were not there. Everything is recorded.
My lord.
So now what is the scope?
My lord, the scope is the tribunal has passed an order on 12th April 2021. Now kindly see.
Oh, this is, sorry, that is
Okay.
another matter. Sorry, that is another.
My lord, my lord.
That is another matter.
Here, my lord has asked them how they will interpret that.
Yes, I have seen that.
My lord.
I have seen that.
My lord.
Oh,
I'm not so afraid of it because.
no.
Yes, yes.
There is another matter which is coming.
My lord.
My lord said, learned from the lordship that you should look at the legal position as to when it is remanded back, whether it means that simply, you know what, simply order should be passed.
Correct.
So in that manner, we got some judgments.
No, first thing is, where is that order of the High Court remitting the matter?
My lord, High Court order is at page 338. And the trial court order is at 380.
No, yes.
$339 is the.
Where is the tribunal's order?
Tribunal order at page
Means
300.
the tribunal order which was challenged before the High Court.
That is at page 318, my lord, tribunal order. Starts from 318.
Show me the ultimate.
336. Last paragraph. Para 14.
Yes. Now the question is, there are two stages of the disciplinary proceeding, probably, correct me. There are two stages. One is at the inquiry stage and another is at the disciplinary authority. Both are different. Inquiry officer, after taking all the evidence, he submits the inquiry report. Report is placed before the disciplinary authority. Disciplinary authority may accept the report, may dissent from the report. Now, it so appears that disciplinary authority, when he accepts the report, then a second show cause has to be issued upon only for the purpose of imposition of penalty. When the tribunal has remitted the matter to the disciplinary authority, what does it mean? That it is only for the purpose of imposition of the penalty that is required to be gone into. Because I find that the entire judgment of the tribunal is that the major penalty which you impose, that really shocked to their conscience in relation to the allegation. So in that event, can you reappoint this, the inquiry officer? Can you go de novo from the stage of service of the charge sheet? I just wanted to know, because what could be the meaning of this word?
My lord, I argued the matter before the tribunal, my lord, when the judgment was passed.
Because
I argued,
yes, cause the penalty order.
Yes.
It really talks about that. This is cause the penalty order, means the penalty which was imposed, that was caused. As well as the appellate order means the appellate order simply affirmed it. And remand the matter back to the disciplinary authority to apply its mind on the fact, evidence and the manner in which allegation should be proved, at least on the basis of preponderance of probability, to arrive on the guilt of the applicant, and while doing so, the disciplinary authority should keep in mind that without corroboration with the independent witnesses, the applicant cannot be proved guilty of demanding and accepting the bribe money, and mere recovery of tainted note of currency cannot be sufficient to prove it, because he relied upon earlier judgment of the Supreme Court, which is quoted as
several judgment I have relied, my lord, and the court arrived to a definite finding it cannot be done. And my lord, criminal case also he was acquitted. No, my lord, that has taken note by the. I know, my lord, two different things.
My submission, my lord, is that we have done exactly what the tribunal asked us.
Sure.
Because my lord, we just see this.
Please.
The round on which the penalty order was quashed is you did not examine independent witnesses. The tribunal tells us that, my lord, we just see that page 337.
Yes.
Matter is remanded back to the disciplinary authority to apply his mind on fact, evidence, and the manner in which allegations should be proved.
Yes.
At least on the basis of
means what it says was that there were an evidence, there were certain, the documentary evidence which came, the manner of proving the evidence, that there was a doubt in their mind that that is not a correct way of doing that. And that's why I say the manner in which the allegation should be proved means what is required to prove the allegation of bribery is to be just. This is what it says, that you will look into that, whether it has been done in a manner which is required to be done, adopted. And then you say on the basis of preponderance of probability, to arrive on a guilt of the applicant, and while doing so, the disciplinary authority should keep in mind that without corroboration by an independent witnesses, the applicant cannot be proved guilty of demanding and accepting bribe money, and mere recovery of the tainted note or a currency is not sufficient to prove the charges leveled against it. That is what it says.
And the word evidence is used, my lord.
My humble submission is, if that was the case, there was no need to remand, because the tribunal.
I also thought. You are correct. I also thought. But one has to understand.
It says, my lord, whenever an order
Let me permit, I am meeting the
Yes.
court frame. So therefore, my humble submission is that here, when the tribunal says you should see the
inquiry officer থেকে আরম্ভ করে ওই এভিডেন্স গুলো সব
what I'm submitting is, my lords, the fault that the tribunal found with us is you did not corroborate with independent witnesses. So, and it should be proven in accordance with law. So that is what we have done. We have corroborated with independent witnesses. It's the search for the truth.
Sorry, I have not. Only thing is, their grievance is that you went and appointed a new inquiry officer. How? I'm just asking you how. So an inquiry officer who have conducted the inquiry have seen the demeanor of the witnesses, has seen everything what has come. He is there in the helm of the affair. He has recorded and returned his finding in the inquiry report. And then an independent inquiry officer, and then he will corroborate.
No, the independent witnesses have corroborated. He was given an
inquiry officer is also an independent third person.
That will be for administrative reasons because it is
what administrative reasons? What administrative
officers reasons? Keep getting transferred, changed.
So what? For this purpose, can you not?
But all that we have done is we have corroborated with independent witnesses. He has chosen not to cross-examine. So, my lords, eventually for searching the truth, my lords, he is coming in the way of arriving at a conclusion as to the truth or otherwise of the allegations. What he wants is, my lords, may I just place the judgments, sir?
Please show us. Show us.
This is the first judgment, Supreme Court 2013 6 SSC 530.
Please.
Here, my lords, in fact, both these questions were looked into.
Please.
And what does it mean when an order is remanded? My lords, may see para 15.1. Para 15.
No, I have a bad habit of reading the whole of the judgment.
My lord.
Just give us, I am very fast reader than you.
No,
don't worry. Just give me just 2 minutes.
My lord. To assist on the legal point, Manoj, I know I'm not saying that it is depends on the way your lordship look at this, but my submission is, my lords, what the Supreme Court is saying is that if in a given case the court comes or tribunal comes to a conclusion that the order is bad for whatever reasons, it is appropriate that the matter should be sent back to the disciplinary authority, and when the matter is sent back to the disciplinary authority, whether the disciplinary authority it is open to the disciplinary authority to start it de novo, depending on how the court perceives the allegations in a given case. So, my lord, this is a case of misconduct. Now, therefore, according
This
to
is not a ratio of the judgment. The ratio is something different.
Yes, ma'am.
Ratio is absolutely different. That's why I kept mum. I wanted to hear from you.
because in my submission 15.1 and
I have
15.2.
seen that. What it says is, it simply says that the court, while quashing the entire proceeding or quashing the penalty of it, on the simply ground that there was a violation of a principle of natural justice or certain statutory rules which permit certain things to be gone into, has not been followed. Then it is a duty of the High Court not to quash the entire proceedings on two grounds. First is there is a considerable delay in already prosecuting with the disciplinary proceeding. That itself is one of the grounds where the court will not remit it back. And the second is the court says that an opportunity has to be given. When you find that there was a violation of principle of natural justice, then an opportunity has to be given. And it is not a simplicity or dismissal, but you have to remit the matter to the disciplinary authority to do so. The court has said that the court must apply its mind that at what stage the entire proceeding vitiates. Then the court has also to apply its mind whether it requires a de novo or it does not require a de novo, or it requires the proceeding to start from a point when this proceeding becomes vitiated. So the logical inference is that if it is vitiated at the stage of a third witness, where the delinquent wanted to put certain questions and those questions were absolutely denied by the inquiry officer, not to be found. And the court subsequently found that these questions are much pertinent questions and the authority have not acted in the right direction to deny that. And the court thereafter paused and set aside the entire. Then what does it mean? That from the stage, when that witness is there, he will be permitted to put those questions and complete with the cross-examination. And from that stage, it all depends upon the facts of the case. At what stage the court feels that the proceeding should continue. Then the question comes the consideration. The consideration has also been defined and explained here. The Supreme Court has said that think over, think afresh. Then also the Supreme Court says that you'll have to indicate at what stage you will do it. And therefore, the court has said that in the penultimate paragraph at 22, that once the court has directed, then the court has clarified the matter is remitted to the disciplinary authority to enable it to take a fresh decision, taking into consideration the gravity of the charges involved, as with respect to whether, please, the liberty was given to the disciplinary authority, as with respect to whether it may still be required to hold a de novo inquiry from the stage that it stood vitiated, that is, after the issuance of the charge sheet. The disciplinary authority, while taking such a decision, must bear in mind that the charges are merely technical. As the loan was taken, then this is what. So it was left to the disciplinary authority to take a decision. Whether you will go a de novo means from the stage of the charge sheet, or you will go from a stage when the proceeding becomes vitiated. Here is not a case. Here, the simple case is remitted back to the disciplinary authority to apply his mind on facts, evidence, and the matter in which the allegation should be proved, at least on the basis of the preponderance of probability. Whether this is probable, because certain evidence I have seen, it says may not, he was whether posted at that point of time, not, something is there. Say, do you apply? You have not applied, mechanically you have proceeded as it appears to be. So this is what one has to understand.
So that is if the court feels that is the direction, then of course that is factually, my lords, if the direction was not, if on a reading of the CAT's order and the Honorable High Court's order, your lordships are of the view that it did not even imply a de novo inquiry, then of course, my lords.
I tell you, the law is very clear in this. First thing is, the judgment should not be read as a statute. We will not go by a strict literal interpretation of the words used in a statute and the word used in a judgment. I settled on this point. I can give you a multiple judgments on this, that it cannot be read as a judgment or a statute. Sorry, judgment cannot be read as a statute. Secondly, one has to uphold the judgment of the court which has attained finality, while ascertaining the meaning of the judgment. Then the court has to overview the other aspects as well. What led the judgment to be pronounced in such fashion? You have to, because what is spoken in the judgment is a last words. I can give you that example of the Supreme Court Constitution bench decision, the state of Maharashtra versus Ramdas Srinivas Nayak, the IR 1982 Supreme Court, page 1264, if I am not wrong. Read that judgment. It says that what has been recorded in the judgment is the last word. Nobody can contradict those. Now, to ascertain, we have to go by a different other aspect what he has dealt with. And it appears to me after this, that that what the court, the tribunal wanted was that you have not really applied your mind while imposing a penalty. You have to look at it, whether there is an independent witness who has corroborated this evidence, whether there is a sufficient materials which are there, which may lead to a conclusion arrived by the inquiry officer. All these things, that's my understanding. I do not know. Please correct me. Still, my mind is open. I tell you.
My lord, there is one more judgment, my lord. I would like.
My mind is still open. I don't.
My lord, the Calcutta High Court judgment, my lord,
Yes.
which according to me is somewhat similar on facts. Short.
How is relevant?
My lord,
Have you seen the ultimate direction passed by the
the
division?
direction is different, my lords. Therefore, it is.
It is specifying. I agree with you that while remanding, the court or the tribunal must specify from what stage the proceeding should continue.
My lords.
If it is totally quas, then the liberty should be granted. De novo, you can start. There is no difficulty. But there appears, but you have to ascertain the meaning.
My submission is, my lords, the cat set it aside on the ground that there was no corroboration, and then the cat
Absolutely.
says that you should apply your mind to how it should be proved. So
Correct.
in my humble submission, this means that you apply the correct procedure to prove,
Yes.
which would mean corroboration by independent witnesses, which is what has been done. And the High Court says revisit. So I'm trying to say that my submission is revisit means that it includes the right to do de novo, although it's not specifically stated. So that is my submission.
সেটাই তো হয় এটা না for interim order on 24/8/2023. But the same was posted on 31st August 2023 as the tribunal found that the counsel for the respondents state for these respondents must be given an opportunity to place all supporting documents pertaining to keeping the name of the petitioner in a list of ineligible candidates. Our attention is drawn to the fact that even on 31st August 2023, despite the prayer having made for passing an interim order, the tribunal adjourned the hearing of the said matter, and the same is fixed
8th of December
on
2023,
8th December
2023.
2022. 2023. Considering the nature of the grievance and the agony and the anguish shown by the petitioner in relation to the said recruitment examination.
Yes, my lord.
In relation to a recruitment examination. The tribunal ought not to have adjourned the matter, as by the time the same is taken up, the position may become irreversible. Since the tribunal directed the state authorities to produce all relevant documents concerning the name of the petitioner having put in the list of the ineligible candidates, we do not find that there is any justification in keeping the matter in the month of December 2023. The liberty is granted to the petitioner to move the tribunal and pray for listing of the instant matter for the purpose of consideration of the prayer for interim order. And if such approach is made, the tribunal shall permit the petitioner to shall put the matter within 4 days therefrom, if necessary, by preponing the date. Since the respondent is before us, the counterpart before the tribunal shall be advised to collect all the relevant documents concerning the issue as indicated in the order dated 24th August 2023 by the tribunal. So, with these observations, the writ petition is disposed of, no order has to pass.
I'm published.
Tell him that he will collect, there is no difficulty.
So this is a public interest litigation.
Yes.
I have
Let it be called.
Item 9 WPAP 8 of 100.
Yes, you are in 9.
Yes, sir. I know. Sir, this is a public interest litigation. I have filed. Actually,
Public interest litigation.
Yes, I am a resident of this island, Diglipur, one of the remote island. We have two facilities to connect to this Port Blair because all the medical facilities are available here. Sir, my parents are 80+ year old. They need treatment, so they need to travel here. We don't have money to hire helicopter or something. We have roads, as you know, the PL has been filed. Last 6-7 years, there is no visible roads because this is for us. It's not.
Then better come because we have fixed those matter at 2 p.m. so that they may take.
And decision PL is about shipping services. There is actually what happened is Andaman Nicobar administration is not buying new ships. What they do was they are hiring ships from sea unworthy ship from foreign countries, and they are paying the money more than the actual cost of a new ship. They have actually what they did was they made an agreement. I have the agreement copy. In that agreement, if you see, they have leased the ship on a hiring basis that they are paying 11 to 12 lakh rupees per day, and that ship is 20-year-old. After the end of its service life, they have hired. So this ship is so CNOD that what as per the agreement that the ship have to run from Port Blair to mainland, but it failed to make a single sailing in the last 5 years. This kind of ship, and the ship originally it is made in the year 1986 and used to sail in French Polynesia. It is made for only 19-kilometer stretch sailing between two islands. But what they did was that same ship they hired, it's CNOD, but this they are paying much more than that, and they prepared a bill. I have arranged the bill also. They have paid around 250 crores. And as per the agreement, the interval, the expenditure for the diesel and all is paid by Andaman administration. It means if you calculate the total bills, it may be more than 400 to 500 crores. But the actual cost of the ship, if someone hire, okay, after the end of its service life, what is the cost? It won't be more than 20, 30 or 50 crores. But the Andaman administration paid more than 200, 250 crores. I have arranged the bill also because I have filed the RTI. So that is the reason. Due to such corruption, we are suffering to such an extent that we have today no boats to sail because of pregnant ladies will be there, females will be there, kids will be there because no visible toilets are there even in the inside the ship. Even if toilets are there, it is not fit for the old age people to sit or any handicapped people. Roads are not there. So where do we go? Because we don't have connectivity. Because for medical facility, we are totally dependent on this Deepak hospital. Because in the remote island, there is no hospital, no doctors, no ICU. Because only option we have either to commit suicide or die there itself. So what I want.
What do you say? This is a very important issue which has been raised. Have you not served the
Sir, I
copy?
have served. I have to go to service has been submitted. I have.
No, I don't have a copy. If you can give, I can come back. This will require detailed affidavit.
No, this is only a proof of dispatch.
Yes.
But proof of service is not
Sir,
here.
I got the message of that. Actually, the
But you'll have to download it and then say that it has to be, it is served, unless it is served. Can you appear for all the respondents? I can give you the names. Union Territory, Administration of the Andaman and Nicobar Island, I think you can. Director Shipping Corporation of India, you can.
No, not shipping corporation. Directorate of Shipping, I cannot. BSS, I appear.
No, it's a Director Shipping Corporation of India. Commissioner cum Secretary Shipping, Andaman and Nicobar Administration, you can. Director Chairperson, CEO, Castle Ships. You have to serve.
Sir, I have sent it by post. Actually, I received message also in my phone.
You'll have to give. Sure.
Also, that
Please submit, then we'll see to it, because our rule says that all these matters, there must be a service of more than 48 hours, at least 48 hours. At least 48. But you have to show us, at least on record, we must say that it is there, service is there. How?
Sir, I received the message.
How can you affirm an affidavit and give it to us?
Submitted by hand.
Please, you have to affirm it. These are the two postal receipts.
Yes.
But that shows that you have dispatched.
I understand.
But service has been affected, you have not shown. That service you have to download from their website,
Yes.
which says that item delivered to the addressee.
Sure.
Then I can understand that it is delivered.
And that is the matter we picked on 26th of this month.
26.
Okay.
Do it, do the service. And pertinent issue, you'll have to answer that. If that being the position, then
So this matter is very serious.
is a very serious thing. If this happens, then you'll have to be responsive to it. You have to be responsive. We'll consider on that day, but you bring all those facts.
Let him give me a copy. Give me a copy.
I'll make another photocopy.
No, administration, so far as the administration is concerned, no difficulty. What about the private one? Because they are more affected person. It appears that the service has not been completed on all the respondents. The copy has been served upon the government pleader and public prosecutor, as well as.
Well, I am aware, my lord, there is no public prosecutor as well. I don't know how he is various.
Government pleader and public prosecutor office has been served in a
He has to serve it to the consent department. There is no such system as well.
The department of the sir.
Recently, the ASG has written a letter to all of us that raising this issue, flagging this issue, that it appears that all these writ petitions against the Union of India, they are served directly to a department. And the ASG office is facing a lot of difficulties in collating those documents because the authorities are not prompt in sending those petitions. And therefore, sometimes the matter goes unrepresented. So he has said that the instruction be given through a department that all these copies should be served in the office of the ASG.
But there is no CP and PP as on date. So I don't know how this is.
I do not know. So, and you are saying just the reverse.
No, that I agree, my lord, that should be the system, but in a situation where there is no purchase.
He is not aware that it is appearing. I do not know. The office has received it. Office is not, is in existence. The person may not be there.
Send it to the department. That's
Okay.
fine.
Give it a copy. Give it a copy.
Advocate Kalim Mohammed, who is a public prosecutor, himself in his office inside the court premises, he have accepted. He himself accepted.
Public prosecutor is not supposed to represent in the PIL. Anyhow, serve the copy on him, extra copy. And the personal cell of the commercial cum secretaryship. Stop. There is no document forthcoming relating to affecting the service upon the private respondents. The service is not complete. However, what is a good name? However, Mr. Satadru Chakravarti, Mr. Satadru Chakravarti appears and submits that he has an authority to represent, that he is an authority to represent the Union of India as well as
Not Union of India. I have no authority.
Union Territory. Acha, he has an authority to appear on behalf of the administration of this island, who are arraigned as respondent number 1. Commissioner cum secretary shipping, you can appear 3. 1 and 3. And prays for a direction to serve a copy of the instant petition upon him. So, the petitioner appearing in person assured this court that the copy of the writ petition would be served upon him
By today itself also.
in course of this day. However, he prays for listing of this matter on 26th September 2023, so that in the meantime he will take all steps with regard to the service of the writ petition upon the other respondents. You give it and come with the instruction. This is a very serious issue.
Yes, ma'am. Indicated. So, my lords, this matter judgments are there, but my lords, since in the transfer matter, my lords, your lordship's judgment, my lords, I wanted to.
Keep it with you. I know what I have. Do you have a copy?
Yes, I got copy to the court, man.
Not for me. Give it.
I hope this is because this, I think this is the judgment in my understanding. There are certain findings which I'll rely because that matter is still pending, it's still alive, my lords. That transfer matter is still alive, my lords, so I will rely on it tomorrow, my lords. On this case also, my lords, had indicated to show that Supreme Court judgment.
One judgment, if you know, please show us. I'm giving a point. Again, you will blame me.
My lord.
That is my characteristic.
That's
And everybody who has appeared before me knows about it.
my lord.
Because if I feel there is a legal point, even if it is not taken, if it is a pure question of law, I will raise it.
My lord.
The only question which stuck in my mind is, I want a judgment from you.
My lord.
Whether let me rephrase the word. Whether the authority
My lord.
can go for a fresh recruitment to the sanctioned post by appointing a contractual person upon replacing the contractual person. Whether that is permissible under the law.
Because on that, there are judgments against us also.
I know the judgment against you that for appointing a contractual person, replacing a contractual person in relation to a sanctioned post, not permissible. I know that. Here you are doing the same thing. If you go for a regular appointment, you are correct. You are within your bounds. No difficulty. But if you go for a contractual appointment again, then you'll have to satisfy.
Yes, ma'am. Unless only thing is, my lord, this, but does it, the question that will arise is whether a contractual employee can say that until such time the regular appointments are made, you cannot.
It's a different one. It's a different one. If we quash the entire recruitment process, then what will happen?
No,
because you are going for a contractual appointment. You are going for a contractual appointment against a sanctioned post, not going for a regular appointment. And I'm really surprised. I've seen this from yesterday or even before. There is already a sanctioned post. I'm really surprised and shocked that for this sanctioned post, the appointments are made on an ad hoc basis or on a contractual basis. Under what law? In a public employment? I am not aware of it.
This advertisement is of, I don't think this advertisement in any case, 2016, this process would have been aborted, my lords. I don't think there is this is a 2016, my lords. Where is the question of?
Has it perished with a natural death?
I would assume so, my lord. Okay, because this is 2016. This paper book is required to be filed, my lord. Incomplete papers have been filed.
My lord, I am for the respondent in this matter, my lord.
Oh.
Limited on which it has been challenged is actually only to say that this appears to be a blanket kind of a protection. Contractual termination should not be covered by this, because, for example, if somebody commits misconduct, does it mean that he cannot be dismissed from service? That is the question, my lord.
Contract has come to an end?
No, my lord, yes, my lord, that is the whole question. So does it mean that I have to constantly keep extending the contract until such time that regular appointments take place? Or does it mean that if the contract comes to an end, I may choose not to reappoint this individual?
Now, the another one. Original order was passed far back. Review after such a long time. Review dismissed on the ground of delay.
So, my lords, on that, your lordship had indicated yesterday, my lords. I've got that Supreme Court judgment, my lords.
2023 was
yes, my lords are indicated. Also,
700, 700?
It is the team copy did, yes, copy did. It is 740. Where the matter has been referred to a larger bench.
I know.
Now here, of course,
say N. No hurry.
But the question is here. The question was.
I was correct up to S until N.
Here the question really is that where in the first round SLP is dismissed as withdrawn, but liberty you can file. You file review, and review gets dismissed. Then when you, because review doesn't have legs.
Yesterday,
yes,
this is a fact. And again, the parent order is challenged.
Yes. So
When
when
it says whether it is permissible.
because first round SLP has dismissed against the parent order. That is not a situation here.
Now question is that suppose if it is done,
Man,
can you get away with the ground of delay and latches?
well, this is a writ petition, my lords. I don't.
Again, the delay and latches is one of the ground where the court will refuse.
Yes, my lords. That,
Limitation, I have not used the word limitation, sir.
my lord.
I have used the word delay and latches.
My lord.
If you want, a lot of judgments are there on that ground.
My lord.
The court can satisfy on a delay and latches. You approach the tribunal 4 years after the main order.
My lord.
Review dismiss. We do not find any illegality in the review, dismissal of the review.
Review is only dismissed on delay. It is not.
But we don't find any.
But the difficulty is, my lords, because my lords may have this judgment. My lords, this is, I don't need to place a judgment for this, my lords, but only thing is, if para 29, where the review is dismissed, can be no merger. And if the review is allowed, then there can be merger. So in that situation, I could have challenged the review order.
I am against.
So I am remediless.
You are no. Sorry. You are assailing an order which was passed as far back as in the year 2016, in the year 2023, in a writ petition. Though there is no period of limitation provided under the Limitation Act for the purpose of writ. But definitely, there are decisions which says that if the delay and latches is attributed to the conduct of the petitioner, then on that ground, the court may refuse to exercise its discretion under Article 226 of the Constitution. So you have to first satisfy the ground of delay and latches from your petition. That what constrained you not to appear, your change of opinion subsequently with the change of the mind or with the change of the officer cannot be said to be a good ground for that. Under the Income Tax Act also, escapement from the notice of the assessing officer, Supreme Court has said that change of opinion or change of mind is not a ground for escapement.
The review was filed 4 years later and COVID period if excluded.
Whatever.
Section 14 benefit.
Did not find. Now forget about it because the review you have filed it, you have challenged that order. We have gone through that order. We does not find there is any illegality because there was no explanation which was offered. Ground for delay.
So I am submitting that I was prosecuting the review. The review was filed 4 years late. If one were to deduct the COVID period, then maybe 3 years late. But if
No, it is not a question of.
so, there's 3 years delay.
That is for the purpose of limitations. You are going by the Limitation Act. I am again saying it is not a question of limitation.
Whether that can be considered.
Delay and latches.
Whether that can be.
During the COVID, whether you were totally functionless. During the COVID, you did not file any matter. You have. You did. The only thing is the conduct.
Because we can file an affidavit on this.
Whatever, you are a petitioner, what more?
A better affidavit to explain the delay.
You can't.
Because ordinarily delay.
No, you can't. In your writ petition, you have you.
The paper book has to be filed, my lord. I don't know. This was before.
Here you have filed a petition, sir.
Yes.
You must have indicated something. You have not indicated. I have seen that.
Unfortunately, it's not.
There is no whisper.
Is not there.
Nothing.
If I may be permitted to file an affidavit to explain the delay, my lord. Since there is no interim order, my lord. There's no scope for interim order. If I may.
Leave is granted to the petitioner to file a supplementary affidavit within a week from date.
My lord.
Before the next circuit. Yes, call the next.
Item 11, affirmative 3 of committee. I am for the petitioner.
My lord, in this matter, respondents are from Cuttack, my lord, legal S, and they have instructed me to file Vakalatnama. Vakalatnama is by speed post, my lord. So I'm undertaking that I would be filing the Vakalatnama.
You are for
I'm for the respondent, legal S of the deceased, respond number 1. It has been filed against their person.
Lord, I have challenged the order of the learned district judge, wherein my application for delay has been dismissed only on the ground that on the wrong noting of the facts that the delay has been caused for more than 12 months, but actually only 6 days was delay. Kindly see, my lord, the order, imping order.
While you say 6 days,
My lord, that is the, I am showing, my lord.
please tell us the date of death.
Yes, my lord.
What is the date of death?
It is in the 15/10/2012,
15,
October 2012.
15/10/2012.
12.
Yes. And when the application was taken up?
4 February 2014.
4th February 2014.
14. Right.
You have taken out the application for substitution and setting aside abatement.
Yes, ma'am.
Yes. So October means 90 days from October. Roughly, it will take us to November, December, and January.
Madam.
And then the 60 days
Madam.
from there. So January means February and March. So in the month of March 2013, the period expired. So from March 2013 and then February 2014, nearly 330 days, if I can go by that.
Madam.
So there is a delay of nearly 330
Madam,
days.
actually the suit was continued until 28th November 2013. On that day, the suit has been abated actually by the Honorable Learned District Judge.
Okay. So according to you?
Yes, within 66 days. On 66 days, I have filed the application.
No, from which date?
From date 28th November 2013.
That is the date for?
When the suit was dismissed for abated by the order of the Learned District Judge.
So the limitation will start from the day when the abatement is recorded.
Yes, madam.
I have to unlearn. I have to unlearn.
Madam,
The abatement is automatic.
automatic, madam. I
It
agree.
does
Madam.
not require any kind of an order to be recorded for abatement.
Madam.
The moment the normal period for limitation in substituting the legal representative expires, immediately the proceeding abates. There are two concepts.
Madam.
Abates against a deceased or abates as a whole.
Madam.
It all depends upon the nature of the claim.
Madam.
So, but it is automatic. From where you got it? From the date of recording, the abatement limitation of 60 days will appear. I have to unlearn everything.
Madam, after the suit was dismissed,
Sir,
we have taken out
sir,
the
this is
application.
merely a formal record.
Madam.
It does not require. Even does not require a formal recording of it. It abates as a whole. It abates. I mean, it abates.
Madam.
So 330 days
Yes,
are
madam.
delayed.
My lord, I will only pray that let the matter be decided on merit, my lord, because the huge money is involved. There are award amount is there. Let the direction may be given only to decide on merit.
So
We have
delay
already deposited.
part we should
We
exclude
No, my lord.
from the book.
No, my lord, I pray for compassionate God, it may be condoned. I request for condoning the delay.
But there must be a ground.
Yes,
How the court can condone? Provided the court finds sufficient cause having shown by the person. What is the sufficiency of the cause?
That we have mentioned, my lord,
What?
the government period.
Engagement of a lawyer from there to that.
Change,
Somebody, then he was taken off the panel.
my lord,
Then he was again included in the panel.
my lord.
Then he was again handed over. Everything you have said.
Yes, ma'am.
So who is responsible? You?
My lord, I agree. I understand, my lord.
The appellant himself was not sure. He changes frequently, changing the lawyer. What can be done? Then he should be penalized for that. Is this a sufficient cause? Then in every litigation, he will go on changing the lawyer. And that would be a sufficient cause.
Even the date of death was not known to the
No,
petitioner.
no, yeah,
What?
At a later date, it came to know, my lord.
no,
But that was recorded.
yes.
The
And,
lawyer was made known because in the
My lord.
record it was communicated that he has expired.
my lord, in the address of the legal heir, without the absence of legal heirs, the could not be proceeded.
From where you got this notion of legal heirs?
My lord.
Who are to be substituted?
The legal heirs of the deceased.
From where you got it? Which provision says the legal heirs or the heirs to be substituted?
It is order 22 rule 4.
Please read that. Show me that that order 22 rule 3 or 4 or 5 uses the word legal heirs. Here, CPC. Quote the governor. Here, give it to him. Give it to him.
My lord,
Yes, sure. That you uses the word heirs, all legal heirs.
procedure in the case of death of one of several dependents or sole dependent.
Yes,
May I read, my lord?
yes,
Where one of two or more dependents died,
yes.
the right to sue does not survive against the surviving dependents or dependents alone, or a sole dependent or sole surviving dependent dies,
Yes.
and the right to sue survives. The court on an application made in that behalf shall cause the legal representative of the
Now,
legal representative.
any legal heirs used? Any word heirs is used?
Legal representative is
So how?
of the deceased.
So why you say heirs? Whether the legal representative is the heir?
Here. Legal representative may be a counsel,
Huh?
maybe a counsel,
Council?
counsel,
No.
maybe
Legal representative is defined in section 2.
section 2.
Yes.
Any person so made a party may make any defense appropriate to his character as legal representative of the deceased defendant.
No. Section 2 of,
2, my lord.
yes, 2, if I am not wrong, 15 or 9, whatever, 11. What is defined? Legal representatives or 5,
11, correct.
11.
Legal representative means a person who in law represents the estate of the deceased person.
So, state.
Estate.
So,
Estate.
the state.
No, my lord.
So, and then,
And includes any person who intermeddles with the estate of the
so
deceased.
lawyer intervenes with the state of a disease.
No, my lord.
So why you say legal heirs?
I stand corrected, my lord.
So-
I stand corrected.
You should.
My-
What to do, sir?
My lord, I
Where is an explanation?
please your lordship to.
How much is due?
My lord, it is award amount is more than 6 crore, my lord.
6 crores.
My lord,
Award is more than 6 crores.
my lord. I have enclosed the copy of the award, my lord. award is at page number 12 of my stay petition.
Now tell me another aspect.
My lord.
As I always create a problem. If section 5 in relation to section 34 of the Arbitration and Conciliation Act is not applicable, you are aware? You can't get the condonation done in a section 34 application. Whether a section 5 application is applicable in that proceeding also.
My lord, section 34 was filed within statutory period in
That
this
means
case.
you could not get a time. You could not get a point. Suppose if section 34 is filed beyond the time which is given in
Yes,
therein,
that is a bar.
then there are a decision that section 5 Limitation Act has no manner of application.
My lord.
Similarly, in a proceeding under section 34, whether section 5 can apply.
Yes,
I'm asking.
my lord, this application is taken under CPC regarding substitution. and
Now question is whether
abatement.
the CPC applies.
My lord, it has to be applied, my lord, on the death of the dependent. There
What?
is-
The Arbitration and Conciliation Act, do you have?
There. I have got one. Limitation. Section 43 deals with
Section 19 come.
'88. Determination of rules of procedure. My lord. The arbitral tribunal shall not be bound by the Code of Civil Procedure or Indian Evidence Act.
Now proceeding is arising or originating from an arbitral tribunal. If the Code of Civil Procedure is not applicable to arbitral tribunal, whether the proceeding originating or is flowing therefrom will be guided by Code of Civil Procedure.
My lord, regarding limitation, section 43, my lord. 43 it says Limitation Act applicable.
What?
Section 43 of the
Yes. Yes. Tell me.
section 43 limitation. The Limitation Act shall apply to arbitrations as it applies to proceedings in court.
Correct. So section 34, the Limitation Act should apply,
There it
but
is.
the judgments are against you.
Yes, madam. There it is not there.
So if in the final proceeding it is not, then whether it is a supplementary proceeding, it will apply. I'm asking this question.
These proceedings.
What do you say?
My lord, we had on 15 October, respond number 1 expired. Within 2 months, we had intimated the same before the learned court below and the council on 17 December 2012. In spite of that, the councils were not taking steps.
If it on merit, section 34 scope is very limited.
No, my lord, but
If it on merit, what is the there?
but my lord, already execution case is pending and for stalling the same. In the year 2018, it has been filed.
Get a automatic this one.
My lord, it has been filed in the year 2018, and for the past 5 years, no steps were taken.
So what?
So, my lord, since
This
the
previous case was filed in 2014.
yes, my lord, but no proper steps were taken by them, and we had intimated the
Should
same.
have 300 days today.
No, my lord.
Should have 300 days. No doubt.
But my lord, there are several number of reasoning, and the application which has been filed right now also is not maintainable
Why
before
not?
the honorable.
Why
My
not
lord.
maintainable? Tell us.
For the same, my lord. I had also sought for undertaking. I'm just praying for 1 day accommodation or 2 days so that I can show the, because my lord, it has been properly given by in the year 2012, intimated 14 January, suit got abated. In spite of that, the counsel who were appearing in the year 2012 and 13, he himself had again came in the year 2014 for filing application. In the entire order sheet, it has been mentioned that several times intimations were given to the learned counsel for the government. But in spite of the same, counsel had stated that I am busy with some other work, so I cannot take necessary steps before the honorable court. And for the same reason, it got continued. And 2014, for about 4 years, they had stalled the matter.
Resolve to the law. How much? Crores.
My lord,
50 amount.
my lord,
Ready with that.
my lord. Highly obliged, my lord. This case appear for the petitioner, my lord.
Why this matter has come up? This matter is otherwise ready for disposal.
My lord, ready.
Stay application has been disposed of.
My lord, ready.
Have you complied the order?
Yes, my lord. We have complied and deposited the amount in the registry.
So paper book has to be filed.
Filed, already filed. Already filed.
Paper book is already.
Already, yes.
So keep it when you are ready for final disposal.
My lord, may take tomorrow, my lord.
My lord, on 25th, it is fixed.
Why? One minute, no, this week anytime.
Then day after tomorrow, because I am not having the paper book also.
Whatever.
Paper book is with senior at Chennai. So.
Yes, to come.
So if day after tomorrow it is
Day after
fixed,
tomorrow, Thursday.
paper book I will be.
Thursday. It appears that the matter has wrongly listed under the heading. That the heading of for admission. Our attention is drawn to the fact that an application for stay of the execution proceeding has already been disposed of on March 16, 2023. Though there is no formal recording of an admission. But in view of the fact that the application for stay has been intervened and disposed of, it would be deemed that the appeal is eligible. The appeal is otherwise ready for hearing and the paper books have been, paper books are filed by the applicant.
My lord.
Let this matter be listed on Thursday.
Highly obliged, my lord.
Always.
Come ready with the shorts.
My lord.
Section 34, you know the scope
My lord.
of the job.
My lord. Obliged, my lord.
Item 13, Section 1 of 2023.
Yes. Where is Mr. Gopala Vindhu Kumar?
Admission seeking leave to challenge judgment will be allowed.
If it is second call, if it does not come, then we dismiss it.
Item 14, SAT 2 of 2023. Item 15, SAT 5 of 2023.
So I'm there for the appellant. Lord, considering the last preceding order, Lord. Lord, I have a substantial question. What I feel,
What is that?
no, I have just formulated in the ground two. Lord, what has happened? No, ground two, my Lord.
Where is ground two?
No, ground two, and to be more precise, ground two, small b, my Lord.
Small?
Small b. This is one, my Lord. And small c also. B and C, this can be admitted, my Lordship. Substantial question of law can be formulated.
No. P is not a substitute.
Not statute says,
Answer is,
not stat, no,
answer is different.
no statute, not, I'll go with the statute, not. Indian
Which
Succession
ground-
Act.
Which was the other ground according to you?
No, C also, not to some
C.
extent, not. No, the first appellate
Yes,
court,
President. No, this is also not. No,
may I try to persuade my Lord?
huh?
No, what I feel, my Lord,
What other?
no, I have taken out altogether, right from A, B, C, D, E, F, my Lord. But what I feel, my Lordship, mainly on
Let us. The appeal shall be heard on the following substantial question of law. Whether the court of appeal below was justified in the whether both the courts below were justified in this uh, in dismissing the suits filed by the appellant, claiming declaration of right title and interest in respect of the subject property, solely on the ground that the moment the will executed in respect of the said property by a person is found to be genuine, it creates a title into a beneficiary / legatee of the said will. Next, whether probate granted in respect of a will has any impact on the right title and interest in respect of a property to which either the testator / testatrix had a fraction of title or no title thereof.
Not, there is a can application being taken out under Order 39 Rule 1 and 2, not because some protection has to be granted.
Whether you were enjoying a protection during the suit.
Yes.
What is the nature of the order?
Status quo with regard to nature, character.
Where is that?
That I have not annexed. I can bring it. I'll bring it. I can let it come. Not should let this retain.
It should go before a
single judge. Yes, no.
Service of the application. The petitioner is directed to serve the copy of an application in CN 1 of 2023 upon the opposite party by speed post and shall file the affidavit of service on the returnable date. The application is made returnable on 28th.
Malay. I'm grateful.
16.
Item 16, MAT 20 of 2023 with CAN 1 and CAN 2 of 2023.
I'm there for the upper.
I'm appearing for respond number 1, 2, and 3, my lord.
What is the matter?
I sought for a leave because I'm not a party before the writ court. The order of the writ court was ordering simpliciter, directing the Tahsildar to take a decision to held demarcation thereafter. Lord, the Tahsildar issued a notice. No decision was taken. He simply issued a demarcation notice in derogatory to the direction of the writ court. Lord, I approached the Tahsildar because a suit is pending in between the interested party. The Tahsildar has, in my intimation letter, has endorsed that the demarcation has to be kept in abeyance till the civil suit is decided. And the same gentleman, the same Tahsildar, what he does later on, again issue a notice. I'm in possession of the land. So I have taken out this mandamus appeal along with the leave to challenge the writ court's order, because I was not arrayed as a party deliberately.
No, what the writ court did.
Not simplicity, as I've said, Lordship. No, kindly see the order once. I'll just take one to that. Tahsildar was that to take a decision because when the suit was filed, when the private respondents being the writ petitioners got the notice, they simply filed the writ without arraying me.
So how it's a simplicity of order for consideration of the.
Lordship, there is suppression of facts. Suppression as regards pendency of the suit has been suppressed. Because upon receipt summons, the writ court was approached without making me a party. The order was obtained. I could understand it's an order in simplicity. What happened thereafter, my lordship? I approached the Tahsildar. I said that since suit is there, I'm in possession. The Tahsildar stays the demarcation. I'll just show that letter.
No, that's true.
Then again, notice was issued for demarcation. When he already stated the demarcation, why second notice for demarcation?
Then you can take out an application for writ. You have taken out the writ.
Yes, so this mandamus appeal is at my instance with the leave.
Why you did not take out the writ application? Why straight away mandamus?
Because entire thing flows from the order of the writ court, which the writ petitioners obtained, whereby the direction has been given to the Tahsildar to
This
consider.
second notice is issued on the basis of this order.
Yes, no, kindly see. Yes, my lord.
But the court has simply said directing him to
No,
take
not
consideration. He will take a consideration.
But not sure the demarcation has been stayed by the Tahsildar. Why again a notice?
Yeah. And they wanted a demarcation.
Yes,
There is already an injunction or no injunction in a suit.
it's an injunction application is pending.
So where is the difficulty?
No, kindly see the page 55 of my stay application. Can one, my lord.
Please.
My lord would find this is a letter by intimating the Tahsildar about the pendency. My lord would find the left hand side endorsement of the Tahsildar. It is addressed to PC5, Patwari Circle 5 / surveyor. Postpone the demarcation till the disposal of the suit. Suit is pending. What Tahsildar did thereafter again issued a notice at page 56. Same gentleman. You not can just for the comparison you can see the signature. Same Tahsildar. When I am in possession, lordship, how demarcation can be done? So lordship, so I'm seeking a leave, not because the rights have not been affected by the writ court's order, lordship. I understand, but the thing is, not
You can agitate. You will simply say that there is no, you are not a party aggrieved in that sense. You can agitate whatever the point, and since the court has simply directed him to consider the representation, it is obvious that the Tahsildar will consider the representation taking into account all the facts.
including giving a notice to me.
Whatever.
That
Given to you.
it has not been. It is no. There are two things. Hearing must precede issuance of demarcation notice. A judicial, an administrative order needs to be passed, then a demarcation would be done.
The question was, there was a representation which is made by them that is required to be considered by him.
A decision has to be taken, my lord.
It's a sticky- So he will take a decision in your presence because he has issued a notice to you as well.
But kindly see, decision has to be taken before issuance of but he has issued the demarcation notice.
No, he has not.
Yes, not kindly see page 56. It's
No.
a notice of demarcation, it's not notice of hearing. Not kindly see the tenor of this page 56 with reference to, it's for demarcation. Kindly see, lordship, with reference to the application dated so and so, dated so and so. I believe that you are is demarcated on 7/7.
Then you challenge this is an independent cause of
This
action.
arises from the writ court order.
No.
Because the Tahsildar is acting in terms of the direction of the writ court.
No. We will make a clarification.
What we propose, lordship,
No.
what we propose, subject to what my lord says.
It will open a floodgate for.
No, lordship, it's not a question of floodgate, not kindly see. I have a right, not I'm in possession. Things are suppressed before the writ court.
You go challenge before the single bench. I can understand that they can't, but this is not a way that you come in a MAT. No, definitely not. Mandamus appeal is not meant for that.
Lord. things
Sorry,
come
clause
about-
15 appeal, clause
I
15 appeal is not meant for
I
that.
understand, Lord,
No.
kindly appreciate.
No.
Kindly
You
appreciate.
go and assail, but not in this way. No. The instant appeal, mandamus appeal has been taken out. Assailing an order dated December 14, 2022. Passed in WPA 811 of 2022. Seeking leave. Along with the leave to prefer the instant appeal. As the appellant herein were not arraigned as a party in the writ petition. The dispute relates to a property, immovable property. And the approach was made by the writ petitioners to the Tehsildar for demarcation thereof.
No, it is at the base of private respondent. Request was made at the base of private respondent. Not by me, my lord.
Not by, I said writ petitioner. I did not say to an appellant.
My lord. I'm so sorry. I'm sorry. I'm sorry.
For demarcation thereof. Since the said representation was kept pending, the approach was made to the writ court for direction upon the Tehsildar to take immediate steps on the basis of the said representation. By the impugned order dated December 14, 2022, the writ petition was disposed of, directing the Tehsildar, Port Blair, South Andaman, to consider and dispose of the representation filed by the writ petitioners therein on 28 September 2022, within 3 weeks from date in accordance with law. The instant appeal has been filed by a non-party alleging that there is a civil suit pending between the appellant and the writ petitioners in respect of the sales and property. And on being apprised of the fact that Tehsildar passed an administrative order of a stay of the demarcation proceeding until the disposal of the said suit. It is further contended that the order passed in a writ petition filed by the writ petitioner therein had been obtained by suppression of fact, and therefore the appellant is aggrieved by such direction. It is further contended that taking advantage of the order of taking advantage of the impugned order passed in the said writ petition, a further notice of demarcation has been issued to the appellant, and therefore the appellant should be regarded as an aggrieved person. Stop. Next paragraph. We are unable to comprehend the submission advanced by the appellant in this regard. The law does not create any fetter into a person who is not impleaded as party in a proceeding to prefer an appeal against the order, provided the order vitally affects his right and he is considered to be an aggrieved person. Every order which does not affect the right of the parties, either in relation to his status or the property, or otherwise, is not amenable to be challenged by such persons. And the court, while granting leave to appeal, must record its satisfaction on the effect of the impugned order upon an appellant. Stop. We have taken an anxious consideration over the facts pleaded in the instant the application seeking leave to appeal, wherefrom it appears that the notice at page 56 of the said application, though issued for demarcating the land, but there cannot be any correlation with the impugned order, which simply directs the Tehsildar to consider and dispose of the representation filed by the writ petitioner therein within a time frame in accordance with law. Obviously, when the petitioner claims semblance of right in respect of the property, it is expected that the Tehsildar would proceed. No, Tehsildar, before proceeding to dispose of the said representation, would afford an opportunity of hearing to all the interested persons. Full stop. There is no allegation forthcoming in the instant matter that there is any defiance of the aforesaid rule, nor there is any apprehensions shown in this regard. So, whether a demarcation notice is within the realm of the power conferred upon the Tehsildar is an independent and as a separate and a distinct cause of action, unrelated with the impugned order, and therefore we cannot grant leave to the appellant to file the instant appeal against the said impugned order. The application seeking leave to appeal is dismissed. Consequently, the appeal is also dismissed. No order is to cause. He is still in dilemma. His facial expression shows.
One thing I want to tell that as per the demarcation notice, within that time demarcation was done and shown the boundaries to the parties.
Yeah, we are not concerned with
My lord.
Next. Next.
This, I pay for the appellant, my lord. Bhagwan Das.
Yes.
Lordship, in this case, judgment and decree was passed by the civil court in the year 2015 against some private parties. Thereafter, in the year 2022, the writ petitioner filed an writ petition.
Whatever you wanted a writ court to be converted into an executing court.
My lord, the writ court has passed a direction to the deputy commissioner to comply with the order of the civil court, whereas the deputy commissioner was not at all a party to the suit in the original civil suit. And that apart, I have challenged on the ground that the said decree was not at all executable, because as per the notification, any land below the 200 square meter of land cannot be subdivided. If it is agricultural land, it cannot be subdivided below than the 200 square meter of the land. Whereas as per the decree, the land is partitioned in small pieces in favor of the writ petitioner. As such, I have challenged this order passed by the learned
So
single
it
judge.
has 300, 200 and 100.
No, even 85 square meter is also there. 84 square meter, 76 square meter. And that apart, another notification declares that the subject village as a local area for conducting revenue survey. When it is declared as a local area, the deputy commissioner has no power to subdivide.
So take all this plea before the because there is a decree staring at your face.
I am not the decree against the private parties.
Whatever, then who are you?
I am a deputy commissioner administration.
That cannot be done. You have to take a decision. You'll have to, if the court has passed a decree, you have to accept it. You can't challenge the decree, being a non-party. You can't challenge the decree. You are not a person affected by the decree. You can approach the executing court. You can approach, but you can't do it.
Kindly see the notification.
Effect the record correction in terms of the decree, which is done in all matters. As in when a decree is obtained.
No, it is not. It is not.
Authority have to act in terms of the local regulation. I applied before the authority with the decree, they were sitting tight with the order. Then I took out the writ application and the order having been passed on 22nd March 2020.
My lord, kindly see the notification.
Which my brother is arguing now has not been raised. Whether he accepted the order and not to see the order of the writ court.
Before the honorable writ court, I did not got the opportunity to file opposition, my lord.
It's not necessary. Can you raise an issue? a decree is passed by the court, and the decree is sought to be respected by all the executives. You have no other authority to do so.
There is this notification is there is a
You were a party in the suit.
no, my lord.
You'll have to. You'll have to. Record the name. Only demarcation is not permissible, physical demarcation. But recording the name, where is the difficulty? And
Even
what the
as per
decree
the
says?
notification, my lord, kindly see page number 29 of my stay application.
Yes. Yes.
Here, this as per this notification, the subject village has been declared as local area village. Once this notification is declaring the subject village as revenue village of
Where does it say?
that is at page
It is
number.
only for the revenue survey,
Yes, ma'am.
only for the purpose of collection of the revenue.
Once it is declared, my lord, the deputy commissioner has no power to subdivide.
It's not a question of subdivision. What is the nature of the decree? I do not know.
Subdivision, ma'am. Subdivision,
Partition means certain properties have been allotted.
Yes,
subdivided.
every decree was drawn up, then the Tahsildar himself was appointed to act as a partition commissioner. He submitted the report in the line of what I am asking. Final decree was drawn up. I approached the DC, being the superior officer, to correct the record. He has to simply correct the record in terms of the report of the Tahsildar, being the subordinate revenue officer. He
It
has
is a
to add it
subdivision,
up.
my lord.
Now I'm not
It is a subdivision. Not the correction of record, it is subdivision. And below 200.
Where is the bar? I do not find from this page 29.
27 may be seen, my lord.
Yes,
Formation of subdivision,
yes,
regulation 48.
yes.
Every portion of survey numbers which is held under a separate title shall be formed into subdivision,
Correct.
provided that no subdivision shall be formed within an area of less than 10 acres if the land is used for the purpose of agriculture.
Correct.
This 10 acres has been changed to amended to 200 square meter, madam.
Where is that? I do not know.
No,
I have
subdivision is
given-
one thing, partition is other thing. My brother is really hotspot with this term. Subdivision under the local regulation is something else, just giving a by number. Partition is something which the trial court has already did. You have to record the correction, that's it. That correct. And the Tahsildar have submitted the report, based on which the final decree was drawn up. Now the deputy commissioner being the superior
I have
officer.
already given madam, the copy once again I am giving. Clause A of Rule 48 shall be substituted as below. With an area of less than 200 square meters if the land is used for purpose of agriculture.
No, I understand it is for the purpose of fragmentation, to avoid fragmentation and to encourage consolidation. That is the purpose of any land reforms in the country.
Yes.
Because the small lands, agricultural land, they will not yield a good produce.
Yes.
So it is only to avoid that.
Here is also, it is an agricultural land and their subdivision is below 84 square meter, 76 square meter is also there.
Yes.
Page number 10.
Where is the difficulty? I do not find 84 square meter proposed area in hectares.
Square meter.
Yes, I understand.
Raja Bhagwan Das. Survey number 102/1/4. Area in square meter 84.
No, I can understand because the proposed land revenue which you want to collect, how you will pay? How you will pay 0.05?
No, it's permissible. For every inch of land revenues are levied. There is no exemption as such under the local regulation.
I am asking you the proposed land revenue in rupees, how you will pay 0.05?
1 rupee, my lord.
1 rupee.
One
How can you? 0.05.
2 rupees for every land in this island. For 200 square meter, every year, 2 rupees is levied. I can show the land revenue, every land for outside within the port of the town. 2 rupees.
2 rupees per?
For 200 square meter, my lord. For 200, 2 rupees is being levied. In terms of the rule by the Tahsildar. There's no legal.
The entire land, 400 square meter, 1200 square meter, 400 and 400. Means it comes around to 800 and 1200, 1200 and 2400 square
For
feet.
every 200, 2 rupees, my lord.
2400 square meter, the total revenue that generates is hardly 2 rupees.
2 rupees. For every 200 square meter, 2 rupees.
2400 square meter.
Yes, my lord.
2 rupees. 35 paisa for one, 45 paisa for another, 70 paisa for another,
Yes, my lord.
and 20 paisa for another. So how much it comes?
In terms of the rules, these amounts have not been in mathematical calculations. In terms of the rules only, my lord.
Do it, you'll have to do it.
No.
It's the civil degree which is binding on you.
But this regulation is otherwise.
Lord, regulation, what my brother is arguing is with regard to subdivision. He's messed up with the term. Under the regulation, there is a different chapter for partition. I've already obtained a
But what is the meaning of partition?
partition. Have already civil court has declared the shares.
I am asking you that what is the concept of partition? Tell
Yes,
me.
every shares will be determined, lordship, by division of shares will be effected, lordship.
Division in what sense?
In the sense, lordship, in the local regulation here, if there is a degree, so far as my case is concerned, the deputy commissioner simply has to record correction of the land.
Can it be
record.
done? Then what is
demarcation would be done.
the demarcation?
Would be done.
Then it is ultimately it is to demarcation means it is division.
No.
Severance under the partition act, not only the shares of the parties are to be declared, but apropos those shares, the property has to be divided by meets and bounds.
Yes, my lord.
So that there is a severance.
My lord.
Severance in all sense. Severance in the sense not only of the recording of the separate number, but also the exclusion of the rights of the others
My lord.
and the exclusive right to enjoy, and then liability to pay the revenue in respect of a
Yes.
demarcated
Yes,
portion.
Yes,
So all these are the incidences of partition by meets and bounds.
yes.
So what he says is that subdivision means they have to divide it, they have to give a separate survey number for that. If that being the position which is not permissible, if it is below 200 square
No, my
meters.
lord. Kindly see regulation
This
16
is
and
what?
local regulation. What
I
my
do not
brother
know.
is saying,
Is a,
what exactly has been mentioned in regulation 69.
so this is what he says.
Subdivision is nothing but not just
This
to
is
give a
what?
by number.
That is what is the, this is
Give a
what
number.
we call it a fraction number.
Absolutely.
This is a fraction number.
Absolutely.
Take the name, 16,
48.
up to 7, 8.
No, 48 is there.
Page number 27.
So this is what is there. No, we'll hear. This is the point which needs to be considered.
This was not raised. Not the first. Secondly, not kindly see the writ court order. They have accepted, not they, rather it
When
is
the
a consent
mandamus has
order.
been issued,
No,
what the
consent
deputy
order.
commissioner will do?
It's a consent order. No, can you see the writ court order?
No, it's not a consent order.
The other side was merely accepting the.
No.
This point was never raised, urged,
No.
nothing.
It was not. It was not. We'll hear out.
My lord.
We'll hear out. Yes, the appeal is admitted. Let the appeal be posted for hearing on next Monday. Can we come after the recess because we have completed up to 17?
My lord, I have handed over with two judgments about that. DM Tank and Paul Anthony, Captain Paul Anthony judgment I have handed over to the court officer. DM Tank. Paul Anthony.
It's called.
Wait, please, sir.
Mr.
We have
Kabir has
been,
also, my lord, we have forwarded the pictures as of now. My lord, what we could make out, my lord, that situation which Mr. Kabir and once all of us was concerned about was due to, my lord, the heavy rainfalls. My lord, as on date, there is no water logging at that portion. My lord, I found out the
What
pictures
we
and
have
forwarded to
done
Mr.
is-
Kabir also.
we have got two perspectives on the matter. One is that the NH officers have sent these pictures, which we have also seen. When the sun is out and shining, there is no problem. It seems to be dry. But when it is raining, the problem is there. Now, we have also got photographs which have been sent to us from the engineers of the APWD, which have shown the road and the sides of the road. There, as far as the condition of the road is concerned, there is no doubt it is in very bad condition, but equally the problem is perhaps construction work on the road is not feasible right now. So far as the emergency situation is concerned, my lord, what I have been able to gather from the APWD is when these situations arise at the time of heavy rainfall, at that point of time, there is going to be required a coordination between NH and APWD to immediately address the situation so that the local residents are not so badly affected. This is for the time being, perhaps all that can be done.
Absolutely.
That coordination can be directed between the APWD and the NH officers in those situations of extreme emergency. Then for the time being, at least the purpose would be solved to keep the situation running.
My lord, what?
My lords,
My lord, may I? My lord, what I could find out, my lord, I had a, my lord, talk over the phone with the concerned persons in several places. Certain portions, what happened, my lord, due to the rise in the sea water, the water couldn't go. There was no escape route for that. And that's why, my lord, this water came and accumulated in the surrounding areas. Now, my lord, so far as our bridges are concerned, I have checked out with my officers. The underneath pass is clear, absolutely. And my lord, there has been an alternate route also created. Now, my lord, it's a general flood-like situation where, my lord, the water has flown. So, my lord, that has got nothing to do with the bridge so far as our construction works is concerned, my lord. So, my lord, what I would, my lord, if for your lordship's consideration, my lord, what I would submit, my lord, both the administration as well as NHI, wherever the administration area is there, which is flooded, the administration will take a call on that. And whenever our help and assistance is required, say suppose a clearance is required, they will tell us and we will immediately, my lord, address that issue.
my lords, I have sought specific instructions, my lords. My lords, my lords it's a suo motu petition, my lords, and of course, my lords may take up whatever issue my lords thinks appropriate. But my lords, this litigation or not this litigation, this petition concerns the construction of the NH4. So, my lords, why this flood happened? It's very all well to say that if the APWD and the administration and NHIDCL as if they are sailing in the same boat. But my lords, it is not exactly like that because my lords, this flood happened. I've got a concerned person from the APWD. He can explain to the court that why this problem of drainage occurred in the first place. If my lords permits, he can apprise the court.
Why it happened?
Yes,
What
my
he
lord,
has
we can-
said, what he has said.
Yes, my lord, he can just explain because there is very little time for me to get brief, my lord. So
Yes.
kindly come forward and explain to the court.
My lord, actually the basic thing is that the stream, previously there was a Bailey bridge. The stream was very free to move, the flow of water was not obstructed. At present, it has been replaced by a Hume pipe culvert. So which actually obstructs the flow of water and in the upstream, it gets flooded. That is one of the main reasons which is flooding the nearby villages, my lord.
So far as the civic areas are concerned, my lords, it is not something which is
Now, kindly visualize. I can understand the high tide is not always.
my lord.
The nature is that sometimes it becomes a high tide and the water recedes,
My lord,
low tides. Then immediately the water gets cleared,
my lord,
has to be cleared.
my lord,
But it appears that when there is an accumulation, then there
My
is
lord.
some kind of an obstruction which is being created in a clearance of the water.
my lord.
So now this obstruction has to be removed.
That, my lord, the NHIDCL has constructed the culvert, so they will,
The culvert is now, they have constructed it. If there is anything which really impedes the, the flow of the water, which is being accumulated at the high tide, then at least that is your responsibility to take care. What he says is just to create a bridge. in between your department and NHA. Both have to work in tandem.
Yes, yes, absolutely, my lord. They'll go undoubtedly.
Has
That
to
goes without-
work. You have to address the issue immediately.
Yes, my
It does not mean that the people of that particular locality would remain stuck up
lord.
for a pretty long time, 3-4 days or 5 days. So this is what we really wanted. We are just trying to create that both of you.
Yes, my lords, absolutely.
Will do it. And we'll see that the accommodation which is there is cleared off immediately and
Yes,
the
sir.
resident of this locality is not.
My lords, as far as
It is not-
the civic areas are concerned, my lords, it is not like it's a special occurrence right now, my lords. It happens as in Calcutta also, my lords, it's aware.
Sometimes, but there is a complete clearance within a half an hour or 1 hour. There is a complete, where there is no clearance. We have taken up an issue for that.
My lord.
The drainage system
So,
that has to be revamped, refurbished,
Pump sets.
have to be
These-
redone.
My lords, these are rural areas and there are paddy fields. So, my lords, water collects on that and when the water falls, it gets cleared. Water level falls, it gets cleared. So when the water level rises, my lords, and the panchayats deal with this.
But the difficulty is some area which they say that there is an accumulation of water for a period of 2, 3, 4 days. That is not acceptable.
No, my lord, that
It can be there for 1 hour, 2 hours, 3 hours, 4 hours, I can understand, but it must get cleared thereafter. Look at your position. If your house is there, then what you will do? You can't come out of your house. And this area has a very unique, the features because it is very close to a sea everywhere, every part. And there are predators, may I use the word, like a crocodile or something. If they come in a residential area, then what will happen?
My lords, my only humble submission is if my lords were to expand say the civic areas flooding, then we will have to apprise the court properly with sufficient, my lords, if the scope is being enlarged to that extent, my lords.
So we are permitting you to file an affidavit and what you have done, you just give us.
Regarding the civic
Yes,
areas.
And for the time being, civic areas, every area where there is already a flood, maybe because of the rain or because of any other reasons.
Yes, my lord.
And it has come up from them that it is because there is no clear passage to
My lord.
water through a drains. And this is a civic problem. Drain has to be kept always clear.
My lord.
This is what you have to do it.
My lord, then that, my lord.
And then we'll have to work together.
My lord, of course.
You have to
only
work
one, my
together.
lord, your lordship kindly permits me that Bailey Bridge was a temporary, my lord, arrangement. That ought to have been removed, my lord, because the bridge has been constructed, the culvert. Over there, my lord, there are 8 supply pipes underneath through which the water can flow. That is my submission, my lord, probably, my lord, the instructing officer may take a visit to that place and find out, my lord, there is no obstruction.
So we are directing that there
My
will be a proper inspection and submit a report by Monday and then still after.
My lord, this
Which
will,
area is this?
And this is at a place called Thoratang.
Suratan.
Thoratang, Swadesh Billy Ground.
Just give the names.
Madam.
Like Thoratang,
Thoratang, Swadesh Billy Ground. Other areas which have been shown in the photographs that we have been able to identify.
which area?
It should have in the corner of at the bottom, it would be mentioned.
My lord, I have mentioned, my lord, in the photograph itself. And I will supply another, my lord, copy, my lord, I couldn't make it.
No, longitude, latitude, everything you have shown. This is a Thoratang.
Suratan,
I
my
can,
lord. And you see, my lord, on the right hand
this
side.
is a Thoratang.
Package for Thoratang.
This is all Thoratang.
The pictures which were, my lord, supplied to us, my lord, we have taken from the same spot. Clear about, my lord.
Therefore, this matter was mentioned.
And just one more thing. The APWD officers have also sent us photographs of the roads further north towards Ziglipur side, some of which have become absolute mud trap. So they are asking also that in those situations, some emergency work can be taken to prevent vehicles having any sort of accident. That only emergency work in those places where the road is completely washed out and become a mud trap.
This matter is mentioned by the special officer appointed in connection with the instant public interest litigation concerning the construction and the repairs of the road leading to Diglipur. leading to Diglipo. Time to time, several directions were passed for repair and the construction of the road. And it has been communicated to us by the appearing councils that a substantial work has already been undertaken. The special officer flagged an issue before us that because of the incessant rain in the recent past, several areas, namely, give those names. Are detached from the rest of the rest of the area. Because of the accumulation of a water, probably due to due to upkeep of the drains. And the resident of the aforesaid localities not only facing immense difficulties in free movement, but are also living in high risk of their life because of the crocodiles or the other aquatic animals getting access to residential areas. Both the councils appearing for the National Highway Authorities as well as the administration are before us, and they were apprised of the opposite facts for which they intended to have the instructions from the respective departments. So we have been shown the photographs taken in the afternoon, indicating that the water which was accumulated in the aforesaid areas has been cleared off. So, however, the administration says that during the high tide, the flow of water through drains is somewhat impeded and or obstructed, which may at times result into an accumulation of the water in the area. But the same is of a temporary nature, as during the low tide, the water is cleared off. There is no difficulty in understanding the natural phenomenon, but the difficulty lies when the water remained accumulated in the area for more than a day or two, which hampers the normal life as the resident of the said localities are stuck up in their residence, and even in case of an emergency, they would be deprived of the essential facilities. during the hearing of the instant matter, we perceive that there is a lack of synergy between the several departments of the administration as well as the national highway authorities. We feel that there should be a convergence amongst the different departments, be it civil authorities or the National Highway Authority, as the paramount consideration is the safety and the security of the citizenry of the country, more particularly the resident of the aforesaid areas. The National Highway Authority says that they have already constructed a culvert and laid a line beneath it for smooth passage of the water, which the administration or the civil authorities have raised an issue in this regard, as according to them, those are not sufficient enough to cater the smooth passage to the water. So we therefore direct both the administration as well as the National Highway Authority to make an inspection and to submit the report before us, indicating any issues or the hurdle being created in release of the water accumulated during the rain, so that the resident of the aforesaid locality may not face may not inculcate any sense of insecurity or a danger to their life. Such report shall be filed by Monday, when the matter would be listed today. Now, next. The special officer has further pointed out that there are certain stretch of land of the road which is totally washed out during the rainy seasons, and the remnants cannot be seen at present. The National Highway Authority is directed to make an immediate arrangement and do whatever work is required to be done in this regard, so that the commuters may not face any difficulties in accessing to the national highway. That's the only way.
One submission that I ought to have made of the first instance. There is an approach road near the newly constructed culvert. That approach road, that I may feel that can also cause some obstruction. Diversion. The diversion is there. We have constructed a culvert.
Do it, whatever you want to do it, and then come submit a report in this regard.
And only things, I'm also a lawyer. Just 1 minute. Instead, my pleasure was to national highways, that is NHIDCL, National Highways Infrastructure Development Corporation.
Read that, NHIDC.
NHIDCL. Great.
I crave to just add few things. Since I'm also practicing from here to Mayavan, every month I used to go. There are 230 kilometers from Calcutta to Mayavan. If we cross the first conway from Nilambur Jetty till Rangar, there is literally no road, only 20 to 25 kilometers there are road. Last time when I was returning back from Mayavandar, God saved me, my vehicle fully slid towards the drain. A truck pulled it out by tying a rope and I came out of it. There is no road literally, my lord, in between the jungles. They have not put even the tar road for once. The condition is so pathetic.
You just file an affidavit in this regard. We permit you to file an affidavit. After the in the interregnum, our attention is drawn to the fact by the practicing advocate of this court that the road connecting which
from Nilambu Baratan to Rangat.
Connecting Nilambu Baratan to Rangat.
And from Kotatang Bridge to Mayavandam.
Under the national highway.
Same.
It's the same. Not even a
has completely been destroyed. And even the vehicles.
Not constructed by
I say sorry.
This was the portion I
Road being the part of the national highway is a part of the national highway, road being the part of the national highway. And therefore the immediate attention is required in this regard, as he recently faced an unprecedented experience when his car skids from the road and about to fall on the nearby ditch. The NHS IDC is also directed to submit a report on Monday in this regard.
And a copy also may be served to us prior to that.
What copy?
The copy that my learned friend will
be. He's permitted to file an affidavit disclosing the aforesaid facts by Monday.
Because this order, my lords, may be uploaded, my lords, today itself.
Why you apprehend that it will not be
I'm
uploaded?
making a request.
Why you apprehend that there must be otherwise bad experience?
Yesterday's orders, all the orders more or less uploaded.
No, some orders where the corrections are to be made, those are not, but those will be uploaded today. Yes.
Passing the order. So Govind neglected to tell your options.
Neglected. What do you say neglected?
Just tell me, he has a top of the line, 4-wheel drive Mahindra Thar. If that car was going off the road, kindly envisage the situation.
There's a 4x4.
And he couldn't get it out.
Half of the portion was totally in a.
So my lord, sedan cars and all cannot come.
Yes.
My lord is making the matter returnable on Monday itself.
Monday.
My lord. Then my lord, if my learned friend can supply me a copy of the affidavit, that issue I will. My lord.
That they have recorded in the order, sir. There is no difficulty, sir. Affidavit we just wanted for the purpose of record, nothing more than that. Okay. There are some Passover matters also there.
Yes, I can see.
Which one you call? Item 2. Come.
Item 2. Lord, I am appearing for the applicant in this matter.
Yes.
Lord, there is an appeal against an order passed by the collector under section 18 of the Act by the Honorable District Judge. There is a delay of 8 days. My lord.
Have you served the copy?
Jayapal was appearing, my lord, in the morning.
Where is he? Colin?
He has filed his objection to that limitation.
He has filed an opposition also.
Yes, my lord.
Section 5.
Yes. He says it was 30 days period is there to prefer an appeal.
Where is the stamp reporter report? Here says delay. When where is Mr. Jayapal? Call him, otherwise we are disposing of the matter. This is passed on 19th of December.
Yes, my lord.
And when you applied for certificate copy?
Not on the
20th of December.
Yes, my lord, on next.
So 1 day, yes, then you
I
got it on
Delivery
22nd,
27, 12.
27th December.
Yes, my lord. It was
27th
ready.
December.
It was
and
ready. I
When
received
you
it
preferred an appeal?
on 28th March.
You preferred an appeal when?
28 March 2022.
20,
8 March 2022.
twenty twenty,
Should be 2023, my lord.
what is the period of limitation?
Lord, it is 90 days, my lord, so far.
90 days. So from 19 has to be
Under-
excluded, then 28th to 27, and then 27th is. It was not a leap year. According to me, it should be. According to me, it should be 2 days.
I mentioned it 8 days because I have excluded.
On section 5, Lordship, I don't stand in the way. So far as section 5 is concerned. But so far as Lord,
Lord, I have already,
there are other submissions to be made.
Lord, I
We are
filed.
not concerned with this. We are concerned with the section 5 now. Yes. This is an application for condonation of delay in filing the instant appeal. This is an application for condonation of delay in filing the instant appeal beyond the statutory period provided therefore.
We are still.
It is a word in the instant application, application that immediately after the impugned judgment and order is passed by the LA court, the application for certified copy was made and obtained on 27th of December 2022. Since the copy of the certified, since the certified copy was received on 29 December 2022, the file was thereafter processed with the department for waiting to prefer an appeal. Immediately after getting the waiting from the concerned department, the present appeal is filed. Stop. The affidavit in opposition filed by the contesting respondent appears to contain the denial of the facts narrated in the application for condonation of delay. After hearing the respective counsels and upon perusal of the amendments made in the said application, it appears to us that because of the procedural hassles requiring a waiting from a concerned department, the appeal could not be filed within the statutory period provided therefore. It is not unknown that the the department takes a longer time to take a decision. And therefore, if any time is consumed, therefore, comma, the court should not view the same seriously, as the encouragement must always be meet to dispose of the matter on merit, rather than to nip in the bud on the anvil of the period of limitation. The application PCN 2023 is hereby allowed. The delay in filing the instant appeal is hereby condoned. The department is directed to formally register the appeal. Application come tomorrow.
Yes, sir.
Then the time to be listed tomorrow.
No, I'm also file and stay application, but it is not listed in that.
Where is that?
I filed it in the registry, not prior to this.
Give the number.
I give the number.
What is the number?
Number is.
He will give a number, list it tomorrow.
Yes, Blair. Blair.
Yes, call the name. Yes. I have handed over these two judgments. Now what to do? This is an interpretation which one has to do. With the order. So we are remitting it back.
My lord.
We are remitting it back, and you proceed on that basis. The disciplinary authority will take an independent decision on the basis of the.
My lord.
We are not going into this aspect of Paul Anthony and GM Tank.
My lord.
That's true. The seminal point involved in the instant writ petition is founded upon the interpretation of the judgment and order passed by the tribunal. Judgment and order dated 12/4/2021 passed by the Central Administrative Tribunal in OA 189 of 2018, by which the matter was remanded to the disciplinary authority to apply his mind on the facts, evidence, and the manner in which the allegation should be proved, at least on the basis of preponderance of probability. In order to arrive on the guilt of the applicant of the writ petitioner. Stop. It was further observed that while discharging such onerous duty cast upon them in terms of the said order, the disciplinary authority shall keep in mind that without corroboration by the independent witnesses, the applicant cannot be proved guilty of demanding or accepting bribe money, and mere recovery of the tainted note / currency cannot be sufficient to prove the charge leveled against the writ petitioner. The narration of facts is required to be adumbrated before we proceed to decide the writ petition on the point raised before us and indicated in the preceding paragraph of this judgment. The disciplinary proceeding was initiated against the petitioner who was posted as assistant sub-inspector on alleged allegedly caught red-handed while accepting the bribe. Bribe money, what bribe itself connotes. Why money?
Right.
By accepting the bribe by a trap team. The preliminary inquiry was conducted, and ultimately the inquiry officer was appointed, who recorded the evidence of the several witnesses and ultimately submitted the report holding that the writ petitioner is guilty of the charges leveled against him as depicted in the article of charges. Simultaneously, a FIR was also lodged against the petitioner, which culminated into an order of acquittal, as the prosecution could not prove the case against the petitioner. Since both the proceedings can run simultaneously, as the consideration required therein are distinct, separate, and different. The disciplinary proceeding continued, and the disciplinary authority accepted the inquiry report and also did not find any cogent explanations offered by the petitioner on the second show cause issued upon him, and proceed and impose the major penalty by dismissing him from service. Dismissal or removal? What? Dismissal. Dismissing him from service. Earlier also they approached the court.
Thereafter, my lord, No, page 78 is the first order passed by the disciplinary authority.
No, no, I'm just talking about, because the last order is passed on.
That was on 2nd March 2023.
Correct. This is that page, ultimate position, the order is at page 328. Sorry, 336 and 37. But prior to that, there was any other proceedings before the tribunal.
No. So far as
Anyhow, we are not concerned with
My lord,
that.
after the dismissal order,
You will achieve. What we have said? Correct. The state order is assumed before the appeal was filed.
Yes, my lord.
So this order was assumed before the appellate authority. But the petitioner could not emerge successful therefrom, as the appeal was dismissed, meaning thereby the order of the disciplinary authority was affirmed. The petitioner challenged the order of the disciplinary authority as well as the appellate authority before the tribunal. In 0189 of 2018. Several issues were raised before the tribunal, including the one that mere recovery of the tainted money without any further corroboration as to a demand and acceptance thereof is not sufficient to hold a person guilty of such serious offense. The petitioner further took a point that there was no application of mind by the disciplinary authority as well as the appellate authority as they proceeded on the ipse dixit of the inquiry report. And therefore, the aforesaid act is contrary to the judgment of the Supreme Court rendered in case of Chairman, LIC of India and others versus A. Masi Lamani, reported in 2013, volume 6, SCC, page 530. A further plea was taken that no independent witnesses have been examined to corroborate the charges leveled against the writ petitioner, and therefore the authorities could not arrive at the decision that the charges have been proved. On the backdrop of the aforesaid submissions having advanced before the tribunal and on the judgments rendered by the different courts, including the Supreme Courts, having noticed, the tribunal set aside the judgment and order, it is set aside the decision of the disciplinary authority as well as the appellate authority. And remanded the matter, and set aside, and also quash the penalty order. Sorry, set aside order. The tribunals quash the penalty order as well as the appellate order, and remand the matter back to the authority to apply his mind in the following. Quote the last paragraph of at page 336 up to 337. Now, apropos stay aforesaid direction passed by the tribunal, the authority, the disciplinary authority, reopened the proceedings by appointing an inquiry officer and summoning the independent, two of the independent witnesses, the so-called independent witnesses.
Inquiry and presenting officer, both were.
And upon recording the same, a fresh inquiry report was submitted, holding the petitioner guilty of charges to stop. The further recourses as available under the statute were exhausted, and ultimately the matter reached to the tribunal. By the appeal order, the tribunal declined to interfere with the order, penalty order, with the ultimate order passed by the disciplinary authority, and did not accept the contention of the petitioner that the authorities have misconstrued and misread the order of the tribunal, which never suggests a de novo, or in other words, reopening of the disciplinary proceedings by appointing a fresh inquiry officer, presenting officer, and calling the so-called independent witnesses. The tribunal did not accept the aforesaid contention as the petitioner being an officer in a disciplined organization is not supposed to act or behave in such manner which would not only tarnish but give ill reputation to such organization. The same point is raised before us, and the seminal point, which is, and the pivotal issue which is raised in the instant writ petition, is whether the tribunal, while disposing of the earlier tribunal applications, intended the reopening of the disciplinary proceedings and adaptation of the recourses as taken by the authorities to stop. We have succinctly narrated the excerpts from the judgment and order dated 12/4/2021, passed in OA 189 of 2018. To understand its real purport, in order to sustain the course of action adopted by the administration, in calling the so-called independent witnesses on appointing the inquiry officer and the presenting officer. It is no longer as integra that the judgment delivered, the judgment pronounced by the court cannot be read as a statute, nor the statutory interpretations or its well-known canon be applied. So, furthermore, in order to understand the ultimate decision taken by the court / tribunal, it would not be safe to squeeze the considerations on the penultimate paragraph of the said judgment, but has to be read in juxtaposition with the findings returned in the preceding paragraphs. The ultimate order has to be understood in the parlance of a context in which the same is used, and should not be segregated or isolated, as sometimes may create an ambiguity and or a confusion. Full stop. In paragraph 1 of the said judgment and order dated 12/4/2021, the tribunal succinctly jotted down the facts emerged from the pleadings as well as the respective submissions of the parties in the following, when quote paragraph 11 at page 326. It is discerned from the aforesaid observations recorded by the tribunal that the disciplinary authority proceeded to conclude the proceedings without examining the independent witnesses of the trap team. And therefore, such an examination is fatal, vitiating the entire disciplinary proceedings. The judgment of the apex court in case of Manisankar versus Union of India and others, reported in 2008, volume 3 SCC 484, was relied upon that the scope of judicial intervention is very limited in relation to a disciplinary proceedings, which is conducted, no, sorry, which is not, to which the Evidence Act does not apply with strict rigidity, but is founded upon the principles of natural justice. The judicial intervention can further be made in the event the finding is arrived on an evidence which is non-existent, or no prudent man should arrive at such conclusions on the basis of the evidence available on the record. The tribunal also found that the formation of an independent opinion by a statutory authority is sine qua non and cannot be whittled down by the statutory authorities. To stop. Ultimately, it was further observed by the tribunal that the recovery of the tainted money is not sufficient unless a cogent evidence with regard to demand and the acceptance are also proved. In the aforesaid perspective, what we cull out from the findings recorded in the said judgment and order, the tribunal remitted the matter to the disciplinary authority to take up its decisions. The ultimate order passed by the tribunal would evince that the entire proceeding was not quashed, but the penalty order, which is affirmed by the appellate authority, was quashed and set aside, and the matter was remitted to the disciplinary authority to take a further decision, to take a decision by applying its mind on the facts, evidence, and the manner in which such charges are to be proved. There is no order on the part of the court while setting aside the order passed by the disciplinary authority in directing the de novo directing the proceeding to be initiated de novo Equally, there is semicolon. Equally, there is no fetter on the part of the court. There is the disciplinary authority to continue the proceeding from a point where the such proceeding is vitiated. In all such cases, it depends upon the nature of the directions passed by the court. And in case of a unambiguous expressions, neither the party nor the court faces any difficulty in understanding the same. But the difficulty often arises when the language used creates a confusion and susceptible to be interpreted in more than one ways. This is what has happened in the instant case. And it is contended by the learned advocate for the administration that the moment the matter is remitted back to the authorities, it presupposes that the same has to be proceeded, and in fact has been done in the instant case, and place reliance upon a judgment of the apex court in case of Chairman Life Insurance Corporation of India and others. And relied upon a judgment of Chairman Life Insurance Corporation of India within bracket Supra. I have already referred. In the above noted decisions, a plea was taken that in course of our inquiry, certain witnesses have not been examined in presence of a delinquent respondent, and therefore no proper opportunity was given to cross-examine such witnesses. A further plea was taken by the delinquent that the documents relied upon by the inquiry officer were not properly proved by any witness, and therefore the finding of the inquiry officer is to be vitiated for non-compliance of the mandatory requirement of the regulations. Regulation 46 within bracket 2, which is quoted in paragraph 12 of the said judgment, indicates that the appellate authority, while imposing any penalty, shall follow shall consider whether the procedure prescribed in these regulations have been duly followed and or complied with, as the non-compliance may result in failure of justice, whether the finding is justified and the penalty imposed is not excessive, inadequate, or adequate, and to pass an order thereupon. What can be seen from the aforesaid provision that a duty was cast upon the appellate authority to return the independent finding and not to give a seal to the order of the disciplinary authority. On the prospectus of the opposite facts, the apex court held that the word consider has to be understood, has to be given, the word consider is of a great significance. And leaves no ambiguity that it requires a conscious application of mind. In the following quote paragraph 19 of the said judgment. Ultimately, the apex court remitted the matter to the disciplinary authority to take a fresh decision, bearing in mind the gravity of the charges involved, and the apex court left it open to the disciplinary authority to take a decision as to whether a de novo inquiry is required from the stage that the inquiry from the stage when the inquiry proceeding becomes vitiated. Stop. In the event there is a clarity in the ultimate decisions, no hurdle can be seen, but the position becomes thickness when the language is somewhat abstruse or blurred. Not blood is not a proper language. It's not a good, correct word. Or does not inexorably lead to clarity of thoughts. The traveler intended. Now, the moment the traveler interfered with the penalty order, obviously taking into account the deposition of the independent witness recorded in the criminal proceeding, and remitted the matter to the disciplinary authority to apply its mind on the facts, evidence, and the manner in which the allegation is required to be proved. It can be reasonably inferred that the tribunal wanted the disciplinary authority to apply its conscious mind and record its independent finding on the basis of the materials available on the record. Had it been an intention of the tribunal to reopen the entire disciplinary proceeding, there was no factor on its part to report the same with clarity. To stop. the expression within court to arrive on the guilt of the applicant has to be understood in the perspective of the facts, evidence, and the manner in which the allegations are required to be proved. How has framed the sentence? Hmm.
Whatever the duty of the office taken is to be understood in the perspective of the facts and the evidence and the manner in which the allegations are given.
Look at. Further observation within court, while doing so, the disciplinary authority shall keep in mind that without corroboration with the independent witness, the applicant cannot be proved guilty of demanding or accepting bribe money. Has to be rendered redundant and cautious. The tribunal was conscious that recovery of the tainted currency is not sufficient to prove the charges of bribery unless there is a convincing evidence in convincing on the demand and the acceptance, as held by this apex court in CM Girish Babu versus CBI within the 2009 volume 3 SSC 779. Furthermore, the interference was made to a penalty order and the appellate order, not touching upon the other proceedings, as the tribunal was of the view that the disciplinary authority has not returned the independent finding on the basis of the materials placed before it. And therefore, in our view, the ultimate direction passed by the trial court, the tribunal, has to be understood in such perspective. We thus do not countenance the stand of the administration that a fresh evidence is required to be taken, nor we could concur with the findings of the tribunal in this regard. The impugned judgment and order of the tribunal is hereby set aside. However, the matter is remitted to the disciplinary authority to take an informed decisions on the imposition of the penalty against the petitioner on the basis of the facts, the evidence, and the manner in which such charges have been proved. And if such findings are made based upon the same, get it out. Score it. It goes without saying that the disciplinary authority is free to take a decision thereupon, irrespective of the fact that this court has interfered with the order. By recording a proper reasons, therefore. It is expected that the entire exercise shall be completed within 3 months from the date of the communication of this order. The tribunal order has been set aside. We say that the course. In the view of that, the order of dismissal, order of the disciplinary authority is hereby caused and set aside. The tribunal order is also caused and set aside. Yes. Can we rise? Let us see. Okay. Yes, please call.
Lordship, can your lordship hear me?
Yes.
Lordship, the very first matter, petition number 1 and 2, I appear for the petitioner. Your lordship, these are applications that have taken out for 4 days of deduction of salary for the period when my clients have been working, only on the ground that they should not have a continuous service. In 2022, we first came before this court, and that is for the first time that they deducted 4 days salary from to show that when they are renewing our services, it was not a continuous process. But in the first matter, there are 15 junior engineers who are contractual, who work on contractual service. And in the second petition, there's one surveyor.
What is the matter about? I have not seen the main matter.
Lordship, the main matter is we have asked for regularization of our services following Uma Devi's case, in the sense that we have been working for more than 10 years against sanctioned posts, and we have not been.
Prior to 2005 or after 2005?
Lordship, we have been working from 2011.
Oh. After Uma Devi intervened.
Your Lordship, may I just make this prayer, humble prayer? Lordship takes up the matter tomorrow because there is a connectivity problem. May I come back tomorrow with both the matters?
No, I don't mind, but sitting in a bar association is a very difficult task.
Lordship, I will ensure that next time I am not in a bar association. That is why I am praying that your Lordship would kindly take up the matters tomorrow. As applications. Lordship, they have come as to be mentioned, let them come as applications.
Yes, let these matters be listed tomorrow as under the heading application.
I'm grateful to your Lordship.
After I've been taken up, my lords, we have actually, my lords, the affidavit is ready, my lords. I'm requesting if it can be taken on record, my lords.
Why not?
My lords,
Where is the difficulty?
Peremptory direction was there,
I'm requesting, my lords, in the interest of justice, my lords, if it. Affidavit not.
Your Lordship, I'm ready for the hearing.
Despite the reply having taken on record, opposition taken on record. Though a peremptory direction was passed upon the respondent to file affidavit in opposition on or before 31st August 2023. The learned advocate for the administration submits that because of the unavoidable and unforeseen circumstances, the same could not be affirmed and or filed within the extended time. However, the affidavit in opposition is ready and he seeks leave to file the same. Considering the fact that an opportunity to defend must be extended to the litigant, the affidavit in opposition filed in court today is accepted and taken on record. Would you like the learned advocate for the petitioner submits that she should not her client does not intend to file reply to the same, and she prayed for the matter to be taken up on merit. Now tell me, who is the petitioner? Yes. Why? 40 minutes.
The authority has framed a guideline or scheme that has been made by the government of India that is dated 15th July 2008. In terms of that particular scheme, the 342 settlers who are in occupation of any government excess land prior to 1961 and continued in possession of that land, there is a scheme that it will be regularized. That is the only clause in that particular scheme that they should continue with the possession. Now, here the petitioner's mother, and thereafter they were continuing with the possession. That is an admitted fact. There is no dispute to that fact. They were continuing. The authorities have taken decision also that it should be regularized. They have taken a conscious decision. But what they did, they sent the matter to the Ministry for approval. There I have objected that there is no requirement for any approval because Ministry has already passed the order that those who are found to be in possession of the property, they have to be regularized.
The ministry in fact framed the scheme.
Yes. Now,
Ministry framed the scheme or administration?
Ministry.
Yes.
Now, Your Lordship, I filed a writ application before this Honorable Court. This Honorable Court passed an order. There is no requirement for any approval of the ministry. The administration is required to deal with the matter and pass the final order. That is the final license or whatever it is. Now, from there, they started the story, Your Lordship. First, they alleged that I am in occupation of excess land, access to that excess land. Means whatever my claim is there, apart from that also I am in occupation of some other government land. I said I'm not there. Whatever land is here, take it. Then ultimately they have evicted some other person from a particular land saying that he was my tenant and evicted him. That matter ended. So there is no problem was there with regard to my landed property. So I was also very happy that my land will be regularized. They have filed a compliance. I filed a contempt application. They filed a compliance also that they are under the regularization is under process. It will be done. Then during the pendency of the compliance, one after another, Your Lordship, they took the date and ultimately they passed an order that regularization cannot be done because I am carrying out commercial activity upon my regularized land as well as the excess land.
Now show us that scheme.
Yes, sir. That is page number 35. May I place, Your Lordship?
No, it's not. I am a fast reader than you. Only two conditions were there.
Yes, only two conditions.
The excess land will be regularized to the extent you are in continued possession. And the second one is specify that the pre-1942 settlees, they were supposed to carry out the survey.
Yes, that survey was completed, measurement was done, area was also
So
specified.
there is no stipulation which is there regarding the commercial or non-commercial.
Moreover, Your Lordship, the government land which has not been licensed till now, what would be the nature of that land? Nobody knows. Only after regularization, only it will be the specification will be there, whether it is occupancy right land.
Where is the order of the High Court?
Yes, Your Lordship, I'm coming to that. Just a minute.
Oh, my order is here.
First order, Your Lordship. That is not the order in this case. I have annexed all the documents, Your Lordship, but that is not required. Your Lordship, that is in another case. The order which is here is page number 56. No, not 56. Just a minute, Your Lordship. Just 1 minute. Page number 168, Your Lordship, may kindly come. 168.
Yes.
This is the order which was passed, Your Lordship, when they decided to take up the matter with the ministry for approval.
Yes. Then
So, Your Lordship, there was no requirement for any further approval and nothing. Now they have to complete the process of regularization.
where is the contempt order where they say that they are in the process of compliance?
Yes, yes. Page number 225.
Yes. What is
Paragraph
this?
18 may be seen.
This
This
is
is the affidavit of compliance.
at page 219.
Page number 219
Yes.
starts with 219.
And the relevant portion is
Paragraph 18.
yes. Then
Your Lordship, we have
what
submitted
happened in the contempt?
contempt, Your Lordship, because they passed the order that on these two grounds, the regularization will not take place. So the court said that you have to file a separate writ application challenging that order.
Where is that?
Yes.
No, this is what they say, that you have to surrender the excess land.
Yes, that I have done. That is completed.
No, that's true. That is what I wanted. Then what happened in the contempt thereafter?
In the contempt, Your Lordship, during the pendency of the contempt application, they passed the impugned order that it cannot be regularized on these two grounds because we are carrying out commercial activity.
Okay, where is then the contempt petition was disposed of? Where is that order?
Yes, that is at page number 287. 286 last portion and thereafter.
Two?
287. Starts at 285.
Yes, liberty to challenge the order passed by the deputy commissioner.
Yes.
Then?
So this writ petition.
Or now this writ petition.
Yes.
And
Now
where is
that-
the order of the commissioner?
Yes, 272. Operative portion I'm showing you, Lordship. It starts from 270.
So is that narrative of the facts and antecedents of the litigation?
Yes. Now 272 last paragraph.
Yes.
In the instant case, it may be found to have
So I
diverted.
have read it.
Yes,
So they say that you have diverted.
yes, diverted the land into, I'm doing certain commercial activities upon that land. That is the reason why it can't. My
Yes, sir.
submission is, yes.
Yes, my first submission is, may have page 169, which is the order passed in the first round. Here, my lords, the only issue that was there before the court was the question whether prior approval is required. That was the only issue,
Correct. So
not on the merits at all.
True. The court has held The court has held that no waiting or the permission from
My
the
lord.
ministry is required,
My lord.
and you'll have to proceed on that basis.
Yes,
and
yes.
Do it.
So my lord, just
There was no.
yes, yes, no, but one thing I wanted to point out, page 169, the direction, the instant writ petition is disposed of directing the respondent number 3 being deputy commissioner to take steps for regularization of excess land which is in possession of the petitioner, description whereof is appearing within period of 2 months.
Yes.
To take steps for regularization only means that it will be regularized if it is otherwise permissible in law. It doesn't mean that because the court was not concerned with the merits of their claim for regularization.
No, that's true.
Now, my lords may see page number 225, the paragraph in the affidavit in compliance which my learned senior relied on. Page 225, para 18 says that the respondent further submits that after submission of affidavit.
Which one? Page?
Page 225.
Yes.
Paragraph 18 says
Yes.
that the respondent further submits that after submission of affidavit by surrendering excess land, the respondent herein will process the file for regularization.
True.
So the file is to be processed for regularization.
Correct.
It is not
Correct.
to keep
Correct.
regularization will be granted. Now, my lords will see page 270. Now, in 270 is the order passed by the deputy commissioner, and my lords will see page 272. Before that, of course, the steps, etc., 270, 271, all the complete history and steps are mentioned. Now, my lords will see accordingly, second paragraph 272, accordingly, proposal for regularization was submitted for approval of competent authority. Honorable Lieutenant Governor raised some queries, original and current classification, agricultural, residential, etc. of the land, and in event of change in land use, whether requisite approvals regularization exists. As per report, land bearing serial number such and such are classified as house site. The allotted area of such and such square meters comprised in is used for commercial purpose without approval of competent authority, and some portion is under residential building. Further report reveals that an area of such and such is being occupied by third party as a shop, which is reportedly under litigation. And then, my lords, the government of India formulated scheme for regularization for fulfilling basic necessity of people to live, dwelling house and agriculture. Intent was to meet basic necessities of life. Accordingly, scheme for regularization of excess land with pre-42 settlers and subsequently regularization for pre-1978 encroach. In the instant case, writ petitioners are found to have diverted the land, allotted land illegally without necessary permission of competent authority. Further, the land proposed for pre-1961 regularization was also reported to have been used for commercial purpose.
Now the question I got you.
My lord.
Sir, very simple. If the scheme provides
My lord.
the regularization of the excess land occupied by those 1942 or 61 settlers,
My lord.
and if there is no stipulation which is provided therein, say in the form of restrictions, can you import those at the time? Because you are regularizing not under the statute. You are regularizing under the scheme. And if the scheme does not take it, you can definitely, because what appears in your survey number, you will definitely regularize as a house site, you will regularize as the agricultural land, you will regularize in that form. What existed and what is there. If they have done something else, then they can be taken to task for that you have now violated this. Till now, they have not been brought within the the four corners of the act because they are occupying the excess land. Their occupation is, say, without any authority. I'm using a very mild term. Not as a trespasser, I'm not saying. Without any authority now. So in that event, where is the difficulty? Your survey number says it's a house site. Regularize it as a house site.
Yes, my lord.
What is the difficulty?
All the land which is
necessary, they have to dismantle those shops. They have to do it.
My lords, the land in the Andaman and Nicobar Islands is governed by the land reform regulations.
I'm again saying when it comes, land reforms regulation requires any regularization of those excess land.
My lords, but
does it require? It does not. It does not. If that being the position, then how under this scheme you can frame? The scheme is for a benefit of those settlers. Then in that event you can't frustrate, because if you go on taking it, the difficulty is the scenario which was there in 1942, nobody has seen, because none of the officers were born in 1942. Today, nobody can claim that I am born in 1942, I know. Because by that time they are retired and I do not know where. So in that event, you have to consider that in that perspective. Then why the scheme was framed? There was no necessity. There was already a regulation. There was already the act in place. What is the necessity? That cannot be done. This is too technical in this. Something which you cannot import.
Malas, if they have violated the law, then for example,
You just till now, kindly visualize this. Till now, you have not taken any steps for recovery of any of the land which is in their possession. If you have decided consciously, the ministry, that you will regularize those squatters, may I use that term, squatters who have illegally occupied the excess land, then in that event, you have to follow that.
is that liberty may be reserved, Malas.
What liberty? So what coming to this is what an interaction. That's why,
My lord.
we say that many things are interacted. That we can't say.
My
Why we will be assuming advisory jurisdiction?
No, I'm not saying.
Then what for you there?
No, I'm only submitting my laws that if this is held, that this is not a ground.
Let us simply go by this. Let us forget what we have said.
My lord,
There is a scheme,
my lord.
and the scheme provides a certain mechanisms.
Yes, my lord.
It does not create any kind of a conditions to be attached to it. At least this condition is not attached to it. Can an authority impose the condition? I am just asking. To frustrate the scheme.
My lords, for example, if that particular area is used for some extreme illegal activity like gambling is going on or prostitution is going on, will the authority be say that no, we'll still regularize?
You are answer, seeking an answer from me. I can give you an answer. And very straight away answer to this. What you are saying is not an apt example. Those are not really an apt example.
My lord. Very well, my lords. I'll leave it at
You know what is there.
Because I leave it at that. I'm only saying that this.
This can't be.
No, okay. My submission is, my lords, there are certain reasons given in the order. So if the order is set aside, it will mean that those reasons are bad.
Absolutely. We are saying that those reasons
are bad to deny regularization, but those reasons may still be hold good in law.
I can't say anything.
I'm only saying clarify that and request.
Simply restrict our judgment on the basis.
Yes, please do that because
on the basis of the scheme, nothing more than that. We will not say anything more.
My laws may be conscious of this request, my laws. Otherwise, it will be misused, my laws. We won't be able to take steps against them. They'll say that the High Court has
not know under the regulation whether this change of user.
Yes, my laws. It's all covered.
I do not know. I just wanted to know from you. It's out of context. Don't take it in this case.
Yes, my lord.
There is a residential building. For some reasons, to augment some income, they have taken one particular room of the building and you're using it as a grocery shop. Tell me whether for that room, any permission is required for change of.
Yes, my lord. From the SBO it's required. Permission is required.
I'm concerned with the Kolkata Municipal Corporation Act.
Here it is required.
I'm concerned there. I do not think so, because the dominant purpose is the residence, and it is a very, very, very small purpose is there.
My lords, because the land is so less in the islands, my lords, so therefore it is land use is required to be protected here, my lords. Otherwise, if there is rampant commercialization, it will ruin the ecology of the islands and also the larger strategy.
Are you identify a particular area to be a residential one only, and a particular area to be commercial only?
Those are designated.
A particular area to be only agriculture, no other activities can be done there. Are you identifying in this fashion? I don't know. I know about the.
It is.
Foreign country, I know there's in Great Britain or in USA, they have identified area and they will not permit any kind of the construction to come except related to, say, if it is an agriculture, only related to agriculture.
It is identified, but I can place an affidavit, my lords, on that. Otherwise, only thing my lords may say that it is restricted to this. Otherwise,
no, only
misuse.
That is you're concerned with. Look, this writ petition has a checkered history. The petitioner has been subjected to several round of litigations concerning the regularization of the access land. as a pre-42 settling,
342 settlers.
as pre-42 settling,
Settlers.
settlers. It is not in dispute that the petitioner is in possession of an excess land and was using, occupying and possessing the same uninterruptedly. From posterity to posterity. Subsequently, the Ministry of Home Affairs promulgated a scheme. Which page?
15th July 2003.
Which page?
Yes, page number 35.
Promulgated a scheme on 15th July 2003 for regularization of the excess land in possession of a pre-1942 settlers within the Port Blair municipal area, subject to the conditions that the excess land shall be regularized only to the extent that the concerned occupants and their descendants have maintained their continued possession till date, and the Andaman and Nicobar administration, and the Andaman and Nicobar administration shall carry out a survey to identify the pre-1942 settlers / their descendants and the exact area of excess land in their possession up to 1961. There is no other conditions attached to the said scheme, which at best can be termed as a beneficial and or a welfare scheme for the purpose of a pre-1942 settlers who have been occupying the excess land in the Port Blair municipal area. Obviously, obviously such a scheme gives impetus to the petitioner to apply before the authority for regularization of the excess land, which was initially denied by the competent authority on the score that approval of the ministry is inevitable. Full stop.
It was not denied, Your Lordship. It was sent to ministry for approval. They have recommended my case.
I have said inevitable. What does it mean?
denied
That without concurrence we can't. So they have sent it.
They have recommended it and then.
Correct.
Your Lordship.
Inevitable. What is the meaning of inevitable?
No, Your Lordship, denied word was used.
No, I have not used the word denied. I have said inevitable. I've used that word. That means without which it cannot continue. That is what is inevitable. Next. The petitioner approached the court, raising an issue that approval of the ministry for regularization of the excess land under the said scheme is not mandatory nor a conditions imposed therein, and therefore the authorities and therefore the administration must take up the call and decide the said application without waiting for an approval from the Ministry of Home Affairs. The said writ petition was disposed of on the said writ petition within bracket WP 84 of 2019 was disposed of on March 11, 2019, directing the Deputy Commissioner, South Andaman, to take steps for regularization of the access land in possession of the petitioner, the description whereof is given in the writ petition within a stipulated time. It was categorically observed that there is no necessity of seeking any permission / approval from the ministry under the said scheme. Despite the same, there was no response from the administration, which constrained the petitioner to file a contempt application before this court. In the affidavit of compliance, the administration took a stand that upon submission of the affidavit by the petitioner with regard to surrendering the excess land, the administration will process the file for regularization of the excess land held by the petitioners in compliance with the order passed by the writ court. While amidst the pendency of the contempt application, the Deputy Commissioner, South Andaman District, passed an order number 3967 dated 17/8/2022, rejecting the claim of the petitioner, primarily on the ground that the petitioner has been found. The petitioners were found to have diverted the allotted land illegally without the necessary permission of the competent authority by using the same for commercial purpose. The aforesaid order of the Deputy Commissioner was filed before the contempt in a contempt application, and ultimately the contempt application was disposed of, granting liberty to the petitioner to assail the said order as it constitute a fresh cause of action. The instant writ petition is a resultant effect of such observation made by the single bench in the contempt application. A point is sought to be raised before this court that the authorities cannot raise an issue which is completely dehones to the scheme framed by the ministry, nor can take any other point, and nor can impose any conditions which is conspicuously absent in the said scheme. Next matter. As indicated above, the only conditions imposed in the said scheme relate to the continuous in possession of the excess land and survey to be carried out to identify a pre-1942 settlers and the exact area of the excess land in their possession up to 1961. Such a scheme, the preamble of the precursor to the set condition is exposite from the set scheme dated 15 July 2003 that the Honorable Prime Minister, during his visit to Andaman and Nicobar Island in January 2003, notice the grievance of the pre-1942 settlers within the Port Blair municipal area, and a conscious policy decision is taken by the government to regularize the access land occupied and possessed by the pre-1942 settlers. The conditions appears to be rational and reasonable, as the person who is not in possession or lost possession subsequently of the access land may not be brought within the ambit of the said scheme. The condition is laudable to the extent that the possession must remain with these pre-1942 settlers or through their descendants as on the date of the said scheme. The further conditions imposed therein emphasizes the obligation of the administration not only to carry out the survey for the purpose of identification of a pre-1942 settlers, but also to ascertain the exact area of excess land in possession of such settlers or their descendants up to 1961. The authority cannot import nor include any conditions which is conspicuously absent in the said welfare scheme framed by the Ministry of Home Affairs. Such benevolent scheme is to give succor to the pre-1942 settlers occupying the excess lands and continuing with the possession thereof. And therefore, the administration has to keep in mind the purpose and object sublime the framing of such scheme. Any strict interpretation which would frustrate the very existence or very purpose of the said scheme should be eschewed. The administration is not supposed to take a stand which is non-existent in the scheme, nor should interpret the scheme in such manner which would render it unworkable. Any interpretation of such scheme now, if the language used in the said scheme are capable of more than one interpretation, comma, the interpretation which lean in the favor of the beneficiary should be adopted by the administration. Since the application for regularization of the access land was taken out under the said scheme, comma, the conditions, the authority cannot take shelter under any other conditions and take shelter under any other conditions which is not incorporated therein, but have to satisfy his conscience on the peripheral of the conditions imposed therein. Whether the land is used for commercial purpose or the purpose for which it is not so recorded, cannot be a ground under the said scheme, as the framer of such scheme were conscious that the object and purpose of framing such a scheme is to regularize the excess land occupied and possessed by the pre-1942 settlers. The authorities cannot travel beyond the periphery of the scheme, nor should impliedly import something which is not incorporated therein, and any such action which appears to the court to have been done beyond the circumference of the said scheme, comma, there is no fetter on the part of the court to set aside such decision of the authorities. We thus, the order impugned now, in view of the findings returned there, the deputy commissioner has exceeded the jurisdiction or the powers conferred under the said scheme, and therefore the decision cannot be sustained. Accordingly, the impugned order passed by the deputy commissioner is hereby quashed and set aside. The deputy commissioner is directed to consider the matter afresh in the light of the observations made herein above. Within 6 weeks from the date of the communication of this order.
One request, my lords. I'm only requesting that the factual correctness of the statement of the contents of the impugned order, either way, my lords, has not observed.
I have consciously avoided anything on that.
Either way, maybe for.
I am again saying consciously.
Very well.
Because I know, I just say the conditions are not there. I
My lord.
just restricted my consideration.
My lord.
Nothing more than that.
My.
If you invite, then many things will come out.
No, my lord, sir.
Obliged.
Yes. Sorry, only one matter was taken up.
My lord.
From tomorrow, I will. My request to the bar At least in a division bench, at least first 10 matters do not ask for adjournment. For reason is because I come ready with those matters. So that it will be easy for you to deliberate thereupon.
We'll try our best, Your Lordship.
And
That's what I can say.
the single bench matter, at least 10 matters.
Would it comment your lordships to call the hearing matters and fix rates? Then we can also.
Let me first see the first top matters. Let us see how much, because as my nature goes, even at the motion stage, if I find, I will dispose of then and there. I will not keep. I will not keep any. There also in the mainland, I don't keep. Straight away on the. So I will just try. And hearing matter definitely I will get.